and serve as a moderator in this wonderful day of ours when we are holding the conference on competition law 2022. Conference is organized and delivered by University of Latvia Faculty of Law in very close cooperation with Rodel and Partner. And today, really, we have very intense program on our tables. Competition law is definitely in the core of every free market democracy, and competition law has a great impact for sustainability of economics, of development of states and policies. Nevertheless, markets are shifting. Markets are shifting fast, which means the regulation at least should follow, in the best case, in the best scenario, regulation should be in advance of the market shifts, and that's really the field we're going to discuss today. And as in every interfield subjects, interfield phenomena, market and competition law definitely can be grasped and discussed if we are bringing at one table many experts from the different fields, state, law, private, academics, all of them coming together. And that's basically what's going to happen today. And we have a great program, very intense, in the 4 sections. Opening keynote remarks and then section on digital markets, economic competitiveness and competition law. Then we're going to move forward to actions for damages for infringements of competition law. And in the second part of the day, we're going to look on the recent developments in competition law and policy, which is very interesting. Our final section is called Rising Stars section, bringing the students at the table, the students from University of Latvia with their presentations on a very topical matters of competition law. Nevertheless, we are not alone in the studio. We are not alone in the digital field. We are absolutely together with you, dear audience. We have been translated online and also on Facebook online, which means whatever platform you are looking us and watching us, just put your comments and questions and remarks and reflections in the commentary field, and we definitely gonna deliver them here in our studio of conference on competition law. We, according to our scenario and the schedule, at the end of every informative session, we have Q&A session or the panel discussion. So definitely your questions can be delivered in our studio. Well, that's for the technicalities. Here, our lingua franca today is English language, but your questions you can also deliver in the Latvian if you have such need. That's for opening. I'm absolutely happy to give the floor now for the welcome speech and the content and the topicality and gravity of the moment to Kristīne Strada-Rozenberga, Dean of the Faculty of Law of the University of Latvia. Madam Dean, the floor is yours.
Thanks very much. At first, some words in Latvian. Kā Latvijas Universitātes pārstāvjiem sveicu visus šajā nozīmīgajā notikumā, un šoreiz mēs pārējām mūs uz angļu valodu, lai viss notiktu raitāk un iekļautos mēs modernajā zinātniskajā un mācības vidē. Good morning, all participants, all speakers, all who are joining us today. I'm honored to address you all today at an event that's become almost a traditional one, the annual conference on current competition law issues. First of all, I would like to thank the initiators of this event, the Rodel and Partners, and especially Laila for the initiative and tireless commitment that has taken place with so many really interesting presentations, and I hope a large audience. Competition law undoubtedly plays an important role in today's legal reality. Fair, legitimate competition is a key to development. At the same time, unfair competition threatens the rule of law and justice. Therefore, the lawyers must stand up for fair competition from the moment we look at its legal framework to ensuring its in practice. Everyday life and people's action create constant challenges to make this process a success. However, it's often the challenges that lead to the highest peaks. However, all this will not happen without the quality of scientific debate that is expected also today. It's a real pleasure to see that this conference looks at a number of current aspects of competition law, including the multidimensional nature of competition law, which is undoubtedly important in both theory and in practice. As a representative of the Faculty of Law, I'm particularly pleased with the idea of giving the floor to young researchers. This seems to have a double benefit, both for those taking the first steps in research and for those who have already experienced it, listening and possibly hearing something that they have not imagined or noticed in their daily and routine life. I believe that high-quality cooperation between young people and enthusiastic and experienced ones provides a successful basis for further discussions and development. I wish everyone a successful and productive event today. May there be ideas-rich reports that spark debates today and also provide a basis for further discussion, research and further improvement in competition law, theory and practice. I wish all of you the best today. Unfortunately, I have to leave because we have a very big event in the university, but I tried to be there for some moments today as well. Wish you all the best and thanks for the floor, and I give the floor to moderator.
Thank you very much indeed, Madam Dean, for such a nice, good speed words, and also for one of the values we have in this conference, sparking ideas and grounding them to reality. Thank you very much. Definitely science, and definitely the fields, they are not isolated in the borders of one country. We are a part of European Union community, and so it's my huge pleasure to invite here with opening words, welcome remarks on the EU courts and competition cases in cooperation with the national courts, Advocate General Laila Medina, Court of Justice of the European Union. Dear Ms. Medina, the floor is yours.
Good morning, everyone. I'm really happy and very proud of being is to set a certain framework of where we are with the competition law, that being both national law and European law, and that being also this is national courts and the European courts, which are there to apply the law and set the legal framework for further implementation then in practice. If I can have the next slide. Just to remind you that there is a judicial system within EU, and both components, that's national courts and European Court of Justice, is there to play a very important role to set the legal scene and also to interpret the rules which are applicable to everyday life. In my first slide, I'm just there to have put some certain lines to remind all of you that the European Court of Justice is there to be an ultimate interpreter of EU law, and there are several mechanisms which are used to interpret the law and to set the legal framework for this, for the national authorities, national courts, and other international players to use and apply in daily life. And there are three of them. That is preliminary reference, which is the most important tool for the European Court of Justice to interpret the law and to tell the story behind the legal norms. There is always, of course, the question of the validity of the norms and also of their legal enforcement. The next slide, if I can. The next slide tells the other part. There is not only the European Court of Justice there, but there are national courts which have a very significant law to apply the EU law and particularly also competition law. And there we see that they have the task to interpret the EU law, to look what the European Court of Justice has said about the specific rules, and then at each and specific case, what they face in their daily life, they have to apply the EU law. But there is one specific moment which has to be reminded over and over again, that in case of doubt, what is the European law, there is a rule, there is a need to ask the question to European Court of Justice, because as I mentioned before, only the Court of Justice is there as a final interpreter of the European law. If I have the next slide. It's also just as a slide of, I'm sure all of you know that, but I'm there to remind of the scene, of the basic, of the background of the EU law, that we can't look at the EU law as something foreign, something far away coming from Brussels or Luxembourg. EU law is our law. It's part of national legal system. And as we look today, EU law is affecting more and more legal areas, more and more different areas of law, and therefore we have to accept that as part of legal identity, that we are there to apply both national and EU law. At the same time, a couple of main principles which I have mentioned, that is always to remember about the primacy of EU law, but not just because we like to call it primer, but because that is the only way how we can ensure equal treatment of all citizens, because only through uniform application of EU law, of all the values put in the legal framework, we can ensure that all member states and all citizens are treated in equal manner. If I can have the next slide. As I mentioned, preliminary reference is the backbone for everything to be there. And therefore, it is very important to ensure cooperation between the national framework and about the European Court of Justice. And that requires active involvement of both parts, European Court of Justice and national courts, because that's the only way how to ensure a European legal debate on the whole EU basis, and have afterwards, when the Court of Justice has adopted its judgments, uniform and binding application of the rules throughout the whole European Union. If I have the next slide. Is also just a reminder and refreshing the memory about the role of national courts in our legal community. That is that every court has a right to refer a question to the European Court of Justice in case of doubts. And it's there for the Supreme Courts to have but the Supreme Courts have the obligation, and I will not go more in details. It's just to remind that when there is a doubt, then always one has to refer the question. But of course, the legal framework provides the possibility of exception, as we are all used to that, and that is when the EU rule has no doubt, then the national court can apply EU law directly, but there is a need to reason why. But it's not only the courts who have the duty to think about the doubts or think about need to clarify the EU law. It is also the parties to the case, or the lawyers representing their respective parties, who have to consider whether the EU law is clear or there is a need to require the opinion from the European Court of Justice. If I can have the next slide. I have been asked to remind or refresh the framework of the legal system, which I did it in 3 minutes, which usually the students in the university study for several months. But I have also been asked to say absolutely few words, like an introduction to the debate we will have today. What is the competition law and what we can see coming from the European Court of Justice and General Court. And here I will have further on a couple of slides prepared to show the statistics. That is to invite all of the participants to follow the cases of European Court of Justice and General Court because of their specific competence and the specific tasks put in the treaty. So that is the place in the judgments of the two respective courts where you can find the interpretation of the law, the direction where it develops, and how it should be seen and how it should be applied respectively in each and every national case. If I can have the next slide. Here it is just a few numbers showing what the court is producing in different areas of competition law. And we can see that both courts, General Court and European Court of Justice, have been rather active in different areas in state aid, which perhaps will not be so much discussed this time, but also in merger control. And if I have the next slide, in abuse of dominant position in the cartel cases, there we see that there is a lot of cases coming from the both courts, a lot of interpretation to read, and this is my task now at this stage to invite you to follow what is happening in Luxembourg, and you will have a wonderful opportunity to talk with or listen to the judges from the court from the general court, and listen to them and ask the questions. I have also tried in these slides to put some information of the activities of the Latvian courts, asking the questions or participating in the cases. And if I can have the next slide. Here we can see that in competition cases in 2020, what has been the share of different areas of law, and in that year we had only one case, and coming from our neighboring country, that is Lithuania. If we can move to the next one. Year 2021 has been a bit more rich from Baltic states. There have been 3 cases from Lithuania and 1 case from Latvia. And if we can look at the next slide, there we can see that until 1st of May this year, we have had already 3 cases from Latvia. And that is just to congratulate that we have become more active and more interested in a way how the EU law should be applied in our national practices, and that in such a manner establish the necessary contact between the two elements of the system. This concludes my very short presentation. I will not be there to take more time from you, the listeners, to enjoy the wonderful speeches of the participants and the invited lecturers. This conference, I will all of you wish a very successful conference. Don't forget to ask the questions. It's a fantastic opportunity to have the representatives from different areas in such a very high relevant law. And having said all these words, I wish you a good conference, good luck, and I hope I have not exceeded too much of the time given to me. And have a good day. Thank you.
Honorable colleagues, and also all the listeners at your screens. Thank you for the opportunity to address you, and especially thanks to the conference organizers who have made an effort to organize an event of this scale. I'm addressing you today on behalf of an institution which is responsible for dealing with competition law issues and disputes. Section 24 of the Civil Procedure Law of Latvia currently provides that the Economic Court, as a court of first instance, examines, among others, the claims for the violations of competition law. The Economic Court, or the Economic Affairs Court, is a brand new court established just a year ago. As none of my fellow colleagues, except myself, has yet shown a particular interest to specialize in competition law matters, the principle of random distribution of cases means that the case can be assigned to any of our 8 judges. It is certainly no surprise to anyone who is familiar with this area that there are usually not many competition law cases compared to other categories of commercial law matters. In about a year since the Economic Court started operating, we have received and initiated a total of 7 cases, which we have identified as competition law claims. 4 of which were received at the end of last year, and 3 have been received this year. What have been the most common grounds of claims so far? In one case, the termination of unfair competition has been requested. In other cases, damages are sought. In one case, the damages are based on the lure of an employee by a competitor. In several other cases, the damages are based on the existence of a cartel. In several cases prior to filing a lawsuit, there have been proceedings in the Competition Council within which a violation of competition has been asked to establish. But in one case, there even have been proceedings in the European Commission. Therefore, this case involves cross-border element. As you can see, despite the small number of cases, there still are different and accompanying circumstances. So far, 2 cases have been decided by a judgment, and both of them this month. Therefore, it can be said that we are only taking our first steps in this area at the moment, and we can't boast ourselves of a considerable experience yet. For these reasons, I commend the initiative of the conference organizers to set up this event, as the extensive exchange of information and ideas between different countries and different institutions contributes to the development of professional qualifications in a context where competition cases are rarely received. I wish all of us today to gain valuable new insights and inspiration for further research. Thank you for your attention and have a great experience today.
Thank you very much indeed for opening remarks to President of the Court, Miķelis Zumbergs, Economic Affairs Court of Latvia, the institution which really in the praxis delivers the questions of economics and competition directly to the field of law. Thank you very much. With this wonderful chain of opening remarks, we are over with the opening of the conference, and now we are diving deeper into informative sections of the conference. Just a kind reminder to all of the audience, you can definitely put your remarks, reflections, and questions in commentary field of the platform you are watching us, is this Facebook or other one, and definitely we're going to deliver your questions and remarks here in the studio. Just a small detail, as always, there is small details in the field. If you are addressing your question to a particular speaker, please write in your comment. My question goes to this speaker particularly, and then post your question so we should know to whom to address it. If you are addressing your question to the universe or all the panel, then just write your question down and we're going to deliver that here in the studio. Well, our first section starts with the topicality of digital markets, economic competitiveness, and competition law. The big frame, the situations now, and the map of meanings and coordinates behind the competition law. My pleasure is to give the floor for our first lecturer and the speaker in the section EU Digital Markets Act. That's the title, the judge, Colm Eochaidh, General Court of the European Union. It's our honor to have you here today, Judge. The floor is yours.
Thank you very much. The pleasure is equally mine to be with you from Luxembourg today. I've chosen the topic of the new Digital Markets Act because I think it represents a fascinating and shift in the way in which the European Union is approaching some very difficult competition questions facing the new digital economy. But perhaps some general words first, and what I intend to do is to explain whether or not the the courts of the union and the union itself have faced difficulties or problems in dealing with this new world of invisible markets that seem to float in the sky above us and can be hard to grasp. And secondly, I will then describe what the legislative response has been, and it's been very recent. Here I'm referring to the recently adopted Digital Markets Act and the soon to be adopted Digital Services Act. All of you will know, anybody who's thought about competition law, antitrust regulation, as they call it in America. You'll understand that it's called antitrust regulation in America because in the 19th century, private trusts or secret organizations of competitors would meet and set prices, divide markets, and operate secret cartels. And these trusts or secret organizations were then outlawed in the beginning of the 20th century by the Sherman Antitrust Regulation. When the European Union or the EEC was set up, it was decided to include as a core principle not just the establishment of a single market, but the establishment of single rules prohibiting anti-competitive behavior and prohibiting the abuse of dominant position. This was to be a core value of the EEC and of the European Union as it then became, not just because pro-competition policies are good in themselves, but that pro-competition policies are critical to the achievement of a single market. So the European Union has always had a dual interest in competition law. One, because it's good for consumers, but two, because it's the backbone of the creation of an internal or one single European market. And in relation to the creation of a single market, the European Union has adopted two approaches. One a form of negative integration and the other a form of positive integration. And negative integration is a series of rules found in the treaty that prohibits obstacles to the creation of or to the existence of the single market. Rules against quantitative restrictions on free movement of goods or on people or on services, prohibitions on anti-competitive behavior, prohibitions on the abuse of dominant positions. These forms of negative integration are about the removal of barriers which might exist to the creation of the single market. But a complementary form of integration creation are the positive integration rules. And these are attempts by the European Union legislatively to put together common rules which remove contrasting or conflicting national rules, because such rules, of course, are obstacles to the creation of the single market. And common rules are normally rules which are adopted, for example, under Article 114 of the Treaty on the Functioning of the Union, which allows the Union and gives the Union the competence to adopt harmonizing rules, to say that in this sector, the following rules shall apply, and they shall apply across all the member states. The member states can't have a different or a conflicting rule. So there has always been these two approaches to the integration of the national economies and the creation of one European economy, the negative and the positive integrationist approach. With respect to the modern digital world, of course, one of the problems that has been faced by the Union is that it was slow to understand the significance and the speed with which the digital world, the digital economy was becoming important and indeed becoming central in the general economy. 15 years ago, people couldn't have understood the concept of WhatsApp or Facebook or Tinder or all of these things which we have become central to our lives. I suspect every single person listening today uses digital services at least once a day, whether you're on your phone and you're lost and you use a mapping service, or whether you quickly need some information and you use a search engine, whether you have an impulse to buy something and you decide to purchase it from the comfort of your couch at home. So from a prediction 20 years ago that there would be one computer in every home, that prediction turns out to be a wild underestimate. Now, for every single person in a home, they have their own computer in their telephones, and these telephones have more computing power than the spacecraft which went to the moon in the 1960s. So we really have moved into a dynamically different world where technology has provided extraordinary economic opportunity and has provided extraordinary services for the people of Europe and indeed around the world to make their lives easier, to give them access to the things they want, hopefully at a price that they can afford. But as we all know, the contradiction in the concept of capitalist free markets is that even though the magic hand of the market is meant to solve all problems, the magic hand of the market will ensure that people will be able to access the goods they want at a price they're willing to pay and will have a choice. We know that that's what the consumers want. We know, and we've all learned, that what businesses want and their ideal world is to have no competition, so that they would set prices and they would, as my economics teacher used to say to me, they would prefer to spend more time on the golf course and less time at the board meeting. And so they tend towards monopoly, they tend towards dominance. And the more they tend towards monopoly and dominance, the worse that is, of course, for the consumers. So it becomes a central role of government, both at national level and at EU level, to try to ensure that the tendency to drift towards monopoly and abuse of dominance is made difficult or impossible, and that where it happens, the consequences of tending towards monopoly or becoming monopolistic are so unpalatable that businesses won't do it, either because they face criminal sanction or because they face ruinous, very hard to pay, pay financial sanctions. And so it's a combination of carrot and stick, but mostly stick, that we try to resist the tendency of businesses to drift towards monopoly. How have we been doing in regulating the new digital world? Well, using negative forms of integration, and that is using the treaty prohibitions, it's fair to say that the European Commission, as the competition law enforcer of the Union and its ally, in this respect, and that is the General Court, where I operate, and the Court of Justice. We haven't exactly been speedy in applying the rules and ensuring that justice is done in a rapid way or in an efficient way. The outstanding features of the digital world, which we are trying to regulate and trying to ensure that it operates in a fair manner, is that there would appear to be a small number of massive companies who have controlling effects on the whole of the digital marketplace. And there is a school of thought that says that the old competition rules with fines of 10%, for example, on global turnover are simply insufficient when the turnover is so massive that a fine of 10% for a company that might have turnover of 200, 300, 400 billion euros a year and might have cash in hand of 150 billion and might have profits of 70 or 80 billion a year. These fines may not be enough to deter them from engaging in repeat behavior. There's also the problem that the application of current competition law rules is simply takes too long, is too complex, and by the time an inquiry is finished, and by the time there is then a judicial review in the General Court and an appeal to the Court of Justice, the thing has taken too long, and the effect of the attempt to apply the rules has effectively been nullified by the length of time the whole thing absolutely has taken. A classic example is the so-called Intel saga, where in January 2022, the General Court partially annulled a decision of the European Commission. That commission, where a 1 billion fine had been imposed, that decision was originally taken by the Commission in 2009, following a complaint that was initiated by a competitor in the year 2000, with an inquiry starting in 2004. So we're looking at a period of almost 20 years for a competition investigation to reach its full conclusion, within the end, the setting aside of a fine by the Commission. And you'd have to say that if that is the best we can do, well, that's not good enough. There has to be a better way. And so there are many examples of how the Commission and the courts have tried to grapple with the new digital world. In March of 2013, the Commission imposed a fine of 561 million on company for ensuring that for connecting Internet Explorer with the users of Microsoft Windows 7. In July 2018, a fine of 4.3 billion euros was imposed on Google for connecting Google and Google Chrome to persons who wish to use the Google App Store. Famously, in the Microsoft case, a fine of 497 billion euro, 100 million euros was imposed on Microsoft for refusing to share information on interoperability of its systems. This was finally upheld in 2013 in the General Court, although there was a slight reduction in the fine. in Amazon has also been subject to significant fines for breaching antitrust rules in relation to online retail markets, and not just by the Commission, but the Italian Competition Authority fined Amazon for 1.1 billion euros for breach of a dominant position in relation to certain services in the marketplaces. Apple was subject to a very significant fine by the Dutch antitrust authority for making an obligation to use its payment services, a condition for dating apps to be sold on its app store. So, as you can see, the Commission and the court have been playing catch up with a very complex market where rules established in the 1950s are sought to be imposed upon a market and services which were beyond the imagination of the people who drafted those rules in the 1950s. And so the old system of complaint and investigations that take years, fine, then judicial review to the court, followed by an appeal to the Court of Justice, followed by a quashing by the court of a decision of the General Court, followed by a rehearing by the General Court. That is too heavy a procedure for the nimble market that is the digital economy. And what the union has done now is that instead of having the negative integrationist approach and applying the rules to alleged breaches and investigating them, they've decided to come up with a set of rules governing some of the big players in this market. And so they've adopted the Digital Markets Act. And I'm going to describe, if I can, what this new piece of legislation does. First of all, it is a regulation, not a directive, and it will have direct applicability in the member states immediately. And what it does is that it tries to identify key players in the digital world, and it identifies them as gatekeepers. And it tries to stop these gatekeepers from imposing unfair conditions on end users and on consumers. And the gatekeepers will be defined in accordance with certain criteria. The first is, what size do you have to be in order to be a gatekeeper? Well, by reference to your financial capacity, if you have turnover in the European Economic Area equal to or above 7.5 billion in each of the last 3 years, you're a gatekeeper. Or where average market capitalization equals to about 75 billion in the last financial year, and you're providing a core platform service. And I'll come to what a platform service is in the last 3 years. So that's the first criteria as for being a gatekeeper. The second criteria is that if you have 45 million monthly users established in the EU, or 10,000 yearly active business users established in the EU. And thirdly, if you have an entrenched and durable position in the market, and that is presumed to be the case if the company meet the first criteria that I have just identified. So if you are a gatekeeper, what happens? Well, after the regulation comes into force, there is a set period within which you have to identify yourself to the European Commission as meeting the criteria of being a gatekeeper. But you also have the possibility of saying, well, just because I meet those criteria, I'm not actually a gatekeeper. So you can rebut that presumption. But in order to be a gatekeeper, what kind of a business services are you providing? Well, the Digital Markets Act does define these, and you must be providing at least one of the following services in order to be a gatekeeper, as well as meeting the size and financial criteria I've just been meeting. So the type of services you must be supplying are the following. So online intermediation services, online search engines, social networking services, video sharing platform services, interpersonal communication services, operating systems, cloud computing services, advertising services, web browsers, and virtual assistants. These last two, web browsers and virtual assistants, were added to the Commission's original proposal at the demand of the European Parliament in the negotiation between Parliament, Commission and Council. Virtual assistants, as far as I can understand it, are sort of artificial intelligence assistants, which are, if I can describe it this way, like Alexa on speed. So this is a new generation of artificial intelligence services to assist you with whatever you need assisting with on the while using the internet. Now, if you are, by virtue of that definition, a gatekeeper, then this new Digital Markets Act provides a list of do's and don'ts. So there are things that you must do and things that you can no longer do. And some of the do's, some of the don'ts rather, are very interesting. And I'll give you some flavor of what's in store for these big gatekeepers. If you are a gatekeeper, you must allow end users to uninstall pre-installed apps or change default settings on operating systems. Interestingly, you have to allow end users to install third-party apps or app stores that interoperate, and you have to allow end users to unsubscribe from core platform services of the gatekeeper as easily as you came onto them. And that one has certainly caught my attention, because without naming the particular household name service that I subscribed to many years ago when I was a practicing barrister in Dublin, I've literally been trying for 10 years to try and unsubscribe. And so at least I don't get their constant messages, because now that I'm in the position of a judge, I have no need to be on this particular career-related service. But my best efforts have literally failed, that I cannot unsubscribe. Companies that provide advertising on their platforms must give information necessary to the advertisers to ensure that fair advertising practices are being observed. Businesses must be allowed to promote their offers and conclude contracts with outside gatekeeper platforms. And the gatekeepers must provide business users with access to the data generated by their activities on the gatekeeper's platform. That is an absolutely central change, which I'm sure the gatekeepers fought long and hard to resist. There are things that gatekeepers cannot do. There's a ban on using the data of business users when gatekeepers are competing with them on their own platform. There's a ban on ranking gatekeepers' own products or services in a more favorable manner than those compared with third parties. That was the issue in the Google shopping case. I was a judge on that case, where the charge was that there were certain shopping services available, which you could find if you Googled you wanted to buy Nike shoes. Google brought you to shopping services, which told you how to buy the shoes. And those shopping services got a little commission every time there was a click. Google set up their own competing shopping services, and suddenly the established ones sort of went out of business. And that's what that case was about. The court upheld the fine imposed on Google, which was 2.6 billion euros, I found. That matter is under appeal. And we'll see what the Court of Justice says about that. There's a ban on requiring app developers to use certain of the gatekeeper services, such as payment methods. That reflects the decision taken by the Dutch Competition Authority. So how will it work in practice? How will this new groundbreaking piece of legislation work? Well, as I say, the first thing is it's a form of self-regulation because companies will have to ask themselves the question, am I a gatekeeper? And then they'll have to notify their result of that questioning to the European Commission. And the Commission can then check that, and they can either agree or disagree with the company's decision, and then they can launch market investigations to see whether or not that company has correctly identified themselves as not being a gatekeeper. And if a person is a gatekeeper, what are the consequences of breaching the rules that I've identified? The game changer here is that there's a significant change in the sort of fines that are available. If a gatekeeper does not comply with the rules, the Commission can impose fines of up to 10% of the company's total worldwide turnover, or 20% in the event of repeated infringements, and periodic payments of up to 5% of the company's total worldwide daily turnover. So that's a very significant difference in the level of fining that's available by comparison to the fines that are available under the general competition rules of the European Union as it currently stands. Who will enforce this Digital Marketing Act? The European Commission will be the sole enforcer of these rules and will have the investigative power to do that. It will do so in cooperation, of course, with the authorities of the member states and with the courts of the member states. But one of the key features of the Digital Marketing Act is because of the fact that it is a regulation, it can be directly enforced by individuals in the national courts of the member states. So an individual who has been required to use a particular payment app, or who has another, unwanted service that comes bundled with whatever internet service he or she was using, can go to the national court and seek a remedy, whether it's an injunctive remedy or indeed seek damages for any harm they may have found. Coming to the end, and I see that I'm at my 30 minutes, as a judge of the court, I can predict that this Digital Marketing Act, which is a complete game changer, in that it sets up a series of rules with which these huge platforms have to comply, rather than, so in advance, rather than investigating practices to see whether they harm competition law. And so the regulation is adopted not under Article 101 and 102 of the Treaty on the Functioning of the European Union, but rather under Article 114, which is the Harmonization Rule or the Single Market Rule. And so it is a very interesting example of how, in order to ensure fair competition and a single market, a set of rules is established not to outlaw anti-competitive practices, but rather to set in place a minimum standard to ensure consumer protection and harmonized internal market rules. But as the regulation itself says, it is complementary to the competition rules, and the regulation is at pains to say that Article 101 and 102 and the competition rules shall still apply. And so the Commission will have the power to ensure that the digital market rules apply, and at the same time can impose competition rules. And so there are both tools available to control and regulate these companies, which have market capitalizations greater than the strength of some of the member states themselves of the European Union. I hope that brief gallop through the way in which the Union and its courts have grappled with digital markets has been useful, and to describe this new groundbreaking approach of dealing with problems before they arise in this new Digital Marketing Act. Thank you very much for your attention, and I hand the floor back to the moderator.
Thank you very much indeed to Honorable Judge, Mr. Eochaidh. Definitely, if you have possibility, we welcome you to stay until the end of this section, because in the Q&A session, you already have a couple of questions coming from the audience. And thank you very much for very informative and at the same time very interesting gallop through the field you are describing and linking the Digital Market Act to this everyday reality of users around the Europe. Thank you very much. So if you have a possibility, please stay until the end of the section for the Q&As. Thank you.
Thank you.
Now we are moving forward, and our next speaker is going to speak on challenges applying competition law in digital markets, relevant market and assessment of its structure. My pleasure is to give the floor to Elīza Roshofa, Competition Counsel of Latvia. Madam Roshofa, the floor is yours.
Good morning, everyone, and big thanks for such interesting insights into Digital Markets Act. My name is Elīza Roshofa, and I am a senior expert of Analytical Department of Competition Counsel. Today, I will tell you a bit about the practical challenges when defining relevant market and assessing market power for digital platforms. Next slide, please. So, to talk about aspects of defining relevant market, one has to understand what a digital platform really is. First of all, platforms are multi-sided, as they bring together at least two groups of users. So the business model of platforms are not linear, as a platform interaction between two or more groups of users. Next slide, please. So further interaction between these user groups can create network effects, which arises when the attractiveness of the platform to one user group increases as the size of the same or another user group of the platform increases. For instance, e-commerce platform can become more attractive to buyers if the number of sellers rises and vice versa, causing these indirect network effects. Network effects have the potential to affect both definition of the relevant market and market power of the platform. For example, indirect network effect fosters creation of a dominant position or even monopoly. Next slide, please. Without going further into the other features of the platforms, I would like to continue with the issues that needs to be assessed in addition to the traditional elements of defining the relevant market. Although, given the challenges posed by platforms, there has been suggestions to put less emphasis on the market definition and to focus more to the theories of harm and identification of anti-competitive strategies. The market definition and assessment of market shares is an essential element. For example, in merger control and when assessing anti-competitive effects on agreement. Therefore, it seems rather unlikely that we will shift away from defining relevant markets. So, established methodologies for defining markets needs to be adapted, and platform-specific aspects has to be taken into account. Next slide, please. Yes. First of all, it is a widespread approach that operators of platform do not charge any price vis-a-vis one user group. Before, it was not considered really necessary to define the market if no monetization takes place. Nevertheless, platforms benefit, for example, from users' personal data or attention, thus affecting the welfare of the consumers. Also, certain conduct on a zero-price market might harm consumers in paid markets. Therefore, it is also necessary to define a market for zero-price products. Next slide, please. As the digital platform is multi-sided, one approach is to define a market for each side of the platform. And this approach has been used, for example, in the MasterCard case, where issuing side and acquiring side of the payment cards was considered as separate markets. Using this approach, each market can be analyzed separately, while taking into account that they are linked by cross-group effects I mentioned earlier. As an alternative, one might define a single market for an intermediation service offered by the platform as a whole. This approach has been used in the cases of so-called matching platforms, for example, hotel booking platforms and dating platforms. According to German competition authority, it is possible to define a single market if demand for both user groups is largely uniform, and the possibilities of the user groups to switch to a different provider don't essentially differ. With this approach, it is important to assess whether substitution is indeed the same for both sides. As an example, both car sharing platform could be considered as matching platform by its definition. At first, it might seem relevant that the market consists of such platforms. Regardless, the substitution on the passenger side could be considerably broader than for drivers, as passengers can use, for example, classic taxi or public transport instead of Bolt. Therefore, the single markets approach in such cases would not be applicable. Next slide, please. So further, if users join only one platform to meet certain needs, they will be single homing. In contrast, if users use more than one platform, they are multi-homing. Investigating these homing patterns is essential for market definition, as the degree of multi-homing or single homing by one group affects the substitution. For example, as you see from the picture, if one side of the platform single homes but other multi-homes, platform provides monopoly access to its set of users on the single homing side. And there might be a separate relevant market for the users that are multi-homing. Here, the platforms will compete for the single homing participants and will then have a monopoly power over the multi-homing participants. Therefore, homing patterns are not only important to assess substitution in the relevant market, but also for evaluating entry barriers and market power. For competition, multi-homing on both sides of the platform might be desirable because undertaking in such cases are forced to compete on both price and quality. Next slide, please. The hypothetical monopolist test is also often used by competition authorities to identify the substitutes to a given product or service. However, as undertakings in digital economy can compete on parameters other than price, such as quality or level of innovation, this complicates the application of the SNP test, in particular in the context of zero-priced products. Moreover, the presence of indirect network effects make the application of SNP test more challenging than in situations where such demand interdependence between user groups do not exist. Therefore, competition authorities and Commission have waived the use of SNP tests in certain cases, stating that the test is not sufficiently conclusive in cases of two-sided markets, and other types of evidence of substitution are equally valid to form the market definition. In such cases, non-price elements like functionality are particularly relevant for the assessment. As an alternative to SNP test, other tests are proposed as they can give some insights about substitution. For example, a small but significant decrease in quality test, which is based on the question, how much traffic would platform lose by decreasing the quality of offered service. Nevertheless, there are also several problems identified with using these alternative tests, so they can only be used as additional proof of substitution. Next slide, please. So yes, further I will tell you a bit more about the market power assessment in the context of the features of digital platforms I told you about at the beginning. Next slide, please. So market shares traditionally have served as a proxy of undertakings market power. In spite of that, a combination of different aspects related to digital economy, like rapidly evolving consumer trends, strong network effects, mean that market shares might not provide the full picture of platforms' market power. Therefore, Commission has acknowledged that the market shares in digital economy is not a reliable indicator of market power. Also, according to German competition authority, these platform-specific aspects make it even impossible to calculate market shares with the usual parameters. Yet, assessment of market shares is necessary, as I mentioned. For example, application of block exemption regulation typically requires that the market share of an undertaking does not exceed a certain threshold. So in practice, alternative ways of calculating market shares are suggested. For example, user-based market shares or market shares based on total time spent on the platform. Next slide, please. So as an authority may find a way how to calculate the market shares, there are several additional factors that has to be taken into account when assessing the market power. First of all, when network effects are present and they are sufficiently strong, users are drawn towards the platform with the highest number of users, make it even more attractive. This can cause market tipping in favor of sole undertaking, and therefore a platform can quickly become a monopolist in the relevant market. Network effects also fosters the consumer lock-ins and switching costs. Switching costs occurs, for example, in the cases of e-commerce platforms, when the vendor reviews cannot be transferred to a different platform. The more useful reviews there are for a particular seller on the platform, the higher are the switching costs for migrating to another platform. Network effects may also lead to barriers to entry due to user coordination failure, as market power also depends on how easy it is for user to coordinate between platforms. Therefore, the aspects of multi-homing and single homing should be analyzed. If multi-homing is possible and it is not associated with higher costs for the users, a user can select the better offer and thereby engage with a new platform whenever preferred. In such cases, market entry tends to be easy. On the other hand, if, for example, participation fee is collected from a platform, or a platform holds a lot of content created by their users, this tends to make multi-homing less attractive. Therefore, even strong network effects do not lead to consumer lock-ins on their own, but only in conjunction with such user coordination problems. The challenge for the authorities is to identify where networks work in favor of an incumbent firm and those cases where they are working into favor of entrant firms. While network effects typically leads to high market shares for one or small number of vendors, the contestability of a market is not necessarily compromised. If market is dynamic and there is potential for innovations, it can be rather easy for entrant to enter the market for innovative undertaking. For example, eBay used to be dominant platform providing intermediation service for handicraft products. Nevertheless, more focused platform Etsy in a few months' time was able to convince many sellers and buyers of handcraft products to switch from eBay to Etsy. This example suggests that entry barriers were not very high in this market as a new and innovative undertaking quite fast entered the market. Therefore, potential competition might mitigate the significance of high market shares as an indicator of market power. But I have to say that as the market gets more mature and platforms make only incremental updates of their offerings, barriers to entry can become a big concern for authorities. Next slide, please. Yes, so to conclude, this shows that relevant market and market power where digital platforms are present should be assessed on a case-by-case analysis. Investigation in these cases needs to be flexible, and it should be not limited from the outset by conventional ideas of market definition and power assessment. One has to keep in mind that alternative mechanisms like direct evidence or profitability could also give useful information about undertaking's market power. The good news, I guess, is that the Commission now is working with new guidelines on how to define the relevant market. So hopefully they will give us more insights on how to assess complex issues in the cases where digital platforms are involved. That is all for me, and thank you for your attention.
Thank you very much indeed to Madam Roshofa from Competition Council of Latvia for this very well detailed and precise story, and we have already a couple of questions from the audience, so I also please Madam Roshofa to stay until the end of this section to participate in Q&A section. Thank you very much. Our next speaker with the topic, the role of economics in competition law, is from RBB Economics Brussels. My pleasure to give the floor to Vitaly Pruzhansky. Mr. Pruzhansky, the floor is yours. Good morning.
Hi, good morning, and thanks very much for inviting me to this forum. It's a pleasure to be here. Put simply, economics is very important, and some of you may probably think, yeah, of course he's going to say that he's an economist after all, but let me explain. Many concepts that we use in competition law and antitrust, such as market or monopoly, or oligopoly, given the term competition. In fact, these terms essentially come from economics, not from law or sociology or any other discipline. They are economic concepts devised by economists, and sometimes devised long before antitrust became a separate discipline of the term. Initially, antitrust was a legal area, primarily a legal area, but as it developed, it became absolutely clear that if we want to apply antitrust wisely, we need to go back to economic fundamentals. And that trend in Europe, and by now you could say most countries with developed antitrust enforcement, have accepted that economics should play a central role, and indeed many competition authorities now employ dedicated teams of economists. Now we can talk a lot about multifaceted role that economics can play in different types of inquiries, but I would like to focus on one basic aspect, and that is a market definition. I think this is typically the first question we need to ask in any competition case. What are the product or geographic boundaries of the market in question? Are we talking about, let's say, market for mineral water or market for soft drinks? Are we talking about sales in Latvia, or maybe sales in the Baltic states, or in the entire European Economic Area, or global? Now, this is all very important, because depending on how we define market, we will calculate market shares differently. And we may arrive at different conclusions about the position of the company on the market in question, or about the level of concentration of the market. And as a matter of good public policy, we would like to avoid mistakes in doing so. We would not want to punish a company for abuse of dominant position if, in fact, it is subject to fierce competition, because doing so will not be good for consumers in the long run. And conversely, we would not want to let a potential problematic merger slip through the net if it really increases market power and has the potential to harm consumers. So it's important to keep these things in mind. Now, how do you define markets in practice? I think, broadly speaking, there are two main principles. First, you have to identify competing products or services. And secondly, you have to look at empirical evidence of substitution. To give an example, if we continue with the case of mineral water, for instance, you cannot just resort to a high-level discussion of the physical characteristics of these products, or talk about whether there are differences in taste or quality or color of these soft drinks. You will need to look at how competition really manifests itself. What consumers actually do when they are presented with a choice. What consumers do if prices change. What consumers do if one of the products becomes temporarily unavailable. These are the questions you need to look at. Consumer surveys could be a great starting point for these analyses. Obviously, you need to ask questions in the right way. Your sample has to be representative. Your results have to be robust. You have to be careful when you design your survey. But it's also possible to employ other, more sophisticated methods. And ideally, the results of different types of analysis should correlate each other. If consumer survey, for instance, gives you one answer, and an analysis of price trends gives you another answer, it does not mean that we are at liberty to choose what we like or what's more convenient for us. It simply means that there is a mistake somewhere. And we need to understand where the problem lies, and we have to be very careful about that. Now, once we've defined the relevant markets and calculated market shares and looked at the level of concentration, typically these are sort of the first ingredients that you need in order to determine whether a company in question has market power. But one has to be very careful here, because market shares, even if undefined correctly, do not tell you the whole story. There are other things that you need to take into account. And one of these things is that economics tells us, is that you have to look very carefully at the barriers to entry and barriers to expansion. For instance, if a firm can satisfy a significant part of demand because it has a lot of spare capacity, that's an important factor to consider. And in fact, if a lot of firms in the market have spare capacity, their market shares may not be really indicative of their market power. The true extent of market power may be much less than is evidenced by their market shares if there is a lot of spare capacity. So again, this is something to keep in mind and treat very carefully. A few words about the market definition in the digital economy. I think Elīza already gave a great introduction to this topic. Probably there isn't much for me to add, but just to make a few points here. Markets in digital markets are often multi-sided, and that means that there are some changes to frameworks, geopolitical frameworks that you need to apply. Just to give an example, social networks such as Facebook attract customers on one side, but they also attract advertisers on the other side. And it may be important to distinguish between these different sides because they may form different markets. And the question whether a particular firm has market power becomes far from trivial in this context. Because maybe, let's say Google is a very popular search engine. Many people use it. And it may be tempting to say, well, Google is dominant. But then you have to look at the other side of the market where competition between Google and Facebook takes place. And that competition may actually be quite fierce. So it's not that simple. And one has to take into account these little things which actually make a lot of difference. And in some instances, you may forget about different sides of the market, sort of lump them together because in a market definition probably should focus on defining one single market for transactions or for sort of the whole matching exercise. And again, Elīza gave a couple of examples illustrating that idea. And what's important, I mean, the main takeaway from this is that you always have to look at the empirical evidence. It's not enough just to make a broad theoretical claim about the fact that something is very popular or that there are certain physical differences in terms of products or services which may be important. What's the key is to look at empirical evidence, to carefully assess what this evidence tells you, and to test those theories against the facts. And one cannot do it differently, but to really look at the case-by-case basis, especially in the areas such as digital markets, which are very, very complex. And I think I'll probably stop here and save more time for discussion. We'll be happy to take questions.
Wonderful insight to Mr. Prozhansky from Brussels, RBB Economics. And more than this, Mr. Prozhansky will come back in the second section also with the topic how to estimate the damage in practice. So thank you very much. And also please stay until the Q&A session because a couple of questions are coming from the audience. Thank you very much. And we are moving forward to our final speaker in the section 1 on digital markets, economic competitiveness and competition law. My pleasure is to give the floor to Dāvis Perševics, Competition Council of Latvia, with the topic the evolution and the use of economical analysis in the Competition Council of Latvia. Mr. Perševics, the floor is yours.
Okay. Hello to everyone here in the conference and to everyone listening. My name is Dāvis Perševics and I'm senior economist of the Economic Analysis and Merger Unit at the Competition Council of Latvia. So today I'm going to tell about economical analysis, the evolution of economical analysis in the Competition Council of Latvia, and review a few of the cases where we used some case-specific methods. So next slide, please. So why we use economical analysis? Well, for example, take for example beer and milk. Both are consumable drinks, but one is an alcoholic beverage and the other one is a dairy product. So these differences between two products lead to different market definitions and show that every market is unique and needs a different approach when choosing the correct analysis type or method, so then the correct type of analysis leads to more precise data, and that leads to more correctly analyzed markets, and therefore more precise conclusions and decisions of the Competition Council. Next slide, please. About the development of economic analysis in the Competition Council. Previously, we relied more on the market share data and contextual analysis of the market. But then in the 2015, the Economic Analysis Unit, now Economic Analysis and Mergers Unit, was established. And since then, we have researched different analysis methods and used more case-specific analysis methods. Next slide, please. So the first case I'm going to talk about is the Group and Form Cinemas Latvia merger case, where both of the parties engaged in film distribution and screenings in cinemas. And there were concerns that the merging parties at the moment were closest competitors in the market. And to find out whether it was true or false, we used the diversion ratios and basically to collect the diversion ratios, there are three ways. One is from business data that is collected during the course of business. This method can be carried out if the merging parties do a follow-up of the leaving customers and ask them where they are diverting to. In some cases, this may be problematic as the merging parties haven't collected this historical data. Also, another way to collect the diversion ratios is through customer data and scanner data from the merging parties. And by using this data, a demand system estimation model can be produced. But also, this relies mostly on the expert that is conducting this type of system, and in the same time also the merging parties need to collect the specific data, and if they do not have this data, then this model cannot be done. And the last way and the easiest way to collect these diversion ratios is from customer surveys. And as I mentioned, the first two ways are difficult as the available data is insufficient, and the results rely on the accuracy of the expert. But customer surveys tend to be most common and practical method for obtaining these diversion ratios in competition cases, and that is why we chose to conduct a consumer survey in this case. Next slide, please. Basically, the diversion ratios measure the proportion of sales captured by different substitute products when the price of product is increased, and is usually expressed as a percentage of sales which company A captures from company B. Diversion ratios measure the degree of competition between two products and indicates the closest substitutes. The higher the percentage, the closer the substitutes the products are. And basically, to obtain the diversion ratios by using consumer surveys, the customers need to be asked the following questions. What brand product did they buy, and choose the last time they bought this specific product or service. What would they do if this product or brand increased their price by 5 or 10%, or this product or brand wasn't available at the time. And if the answer to the last question was to switch to different brand, then the next question is to ask which competitor brand would they switch to. And these questions would give enough data to calculate the diversion ratios between different brand products and services, and that would give the possibility to indicate the closest substitutes. In this specific case, there were concerns that the merging parties were quite close or the closest competitors in the market. So we carried out a consumer survey, including the SNP test, which is small but significant and non-transitionary increase in price. Also, we added questions to specify the relevant market, both product and geographic, and also to obtain the aforementioned diversion ratios. And the collected data indicated that cinema customers mainly chose between the offerings of multi-screen cinemas, for example, Apollo Kino, Forum Cinemas, Cinnamon, and Multi-Kino, when choosing which cinema to visit, and that cinema customers chose a cinema by considering the offer of several cinemas. Therefore, it was concluded that cinemas face competition from each other, and less competition from smaller, more specific type of cinemas. And in addition, the survey data, the collected diversion ratios show that the merging parties were the closest competitors, and the merger would provide an increased incentive for the merged entity price. In retrospect, if we had not chosen this method, it would have been a lot harder to prove that the merging parties are the closest substitutes to each other, as market shares do not reflect the closeness of competition. Next slide, please. So the next case I'm going to talk about is Beta Latvia and Baltic merger case. Beta Latvia is a mobile operator that performs prepaid and postpaid mobile services, while Baltic is a telecommunications operator that provides fixed internet services, television broadcasting services, and Beta had previously acquired via Media Latvia, which operates in the production and wholesale of TV channels markets in Latvia. And as Baltic is one of the providers in Latvia, there were concerns that Beta could reduce or completely then limit the sales of TV channels to competitors of Baltic, and to analyze whether it is feasible or even possible to carry out this theory of harm, we used vertical arithmetics. Why are they called vertical arithmetics? Basically, they are called vertical arithmetics as the merger is happening in the vertical level. That is when a product or service producer company is acquiring company that provides or distributes the aforementioned product or service, as in this case, Beta, the parent company of Media Latvia, which produces TV channels, was acquiring Baltic, which provides the aforementioned channels to consumers. Next slide, please. So the vertical arithmetics uses market data and sales data to show whether it is feasible for a company to limit its sales to competitors in the upstream market, in this case, Beta and Media Latvia, and in doing so, increase its sales in downstream market, in this case, Baltic. So basically, it means that the losses of the limiting sales of upstream market should be lower than the increase of sales in the downstream market. In this case, we used the same logic of this analysis, but adjusted it to this specific case. So we calculated the amount of new customers that Baltic needs to gain from competitors for the limiting in upstream market or Media Latvia to be feasible. In the end, the total amount of customers, the customers that it already had, and plus the customers that it needed to take from competitors were greater than it had historically had, and they did not have the capacity to carry out this scenario. Also, in the end of reviewing this case, the structural remedies imposed in the previous case when BIT acquired Almedi Latvia, these structural remedies were enough to make sure that they cannot delimit the sales in the upstream market, so there were not this theory of harm cannot be carried out. Also, the main problem with vertical arithmetic method is that it is only applicable in vertical markets where product or service in the upstream market is unique or there is no direct substitute, as if the products were not unique and there were a direct substitute, the competitors would just switch to another supplier. So next slide, please. The next case I'm going to talk about is Diversion and Baltic milk merger case, which was a merger between two largest market players in a highly concentrated market. So Diversion and Rigas, which is a subsidiary company of Baltic Milk, are two of the largest producers of grain processing and flour products in the Baltics. And in this case, there were concerns that the merger would significantly reduce competition, give market power for the merger density, and the opportunity to raise prices as there were no close substitutes. As there were multiple affected markets, we used a variety of analysis methods, for example, sales and market share data correlation, carried out consumer survey and gained diversion ratios, and also carried out bidding market analysis. So next slide, please. So not to repeat about the consumer survey, I'm going to talk about the correlation analysis. The data correlation analysis can be used for more than one type of data, for example, sales data or market shares. Usually, we look at correlation as a statistical term describing the degree to which two variables move in coordination with one another. But in this case, in these competition cases, we look more at negative correlation to test the substitutability of between the two products or services, and the closer the correlation is to -1, the closer the substitution between the products. And also this can be seen in the graphic chart or the data as the orange line of product A market share moves in the opposite direction of the gray line of product B market share. And this is a more of a visual representation of a negative correlation and may be more understandable, as if the market share of product A increases, the market share of product B decreases. And in this case, the correlation analysis showed that in some of the defined product markets, the merging parties were closest substitutes to each other. Next slide, please. And another analysis we carried out in this case were the bidding analysis. And this type of analysis is performed in markets where companies bid for contracts, tenders. For example, in this case, the flour product providers tenders for the biggest bakery product manufacturers, confectionery manufacturers, and so on. So the bidding market analysis may indicate whether market shares of the specific market are relevant and may indicate market power, as the tender are more infrequent and appoints bigger amount of total tender amount in the specific market, the more indicative are the market shares. As the tenders are more frequent, the market share calculated yesterday may not be the same as the market share calculated today, as the bids for tenders change on a day-to-day basis. That is why it is more appropriate to use bidding analysis on these type of markets. So what does the bidding market analysis, what it is basically? It measures how often do market participants have a chance to win or lose market share basically win or lose contracts. How often do merging parties meet in the formation and tenders? Also, it measures how often do one of the merging party wins the bid for a tender, and how often in these cases does the other merging party come in second to the other merging party, and this shows whether the merging parties are close substitutes to each other. And also it measures the price closeness and overall closeness of the competition in the market. The results of this analysis can help identify the strength of the competitive constraints between each of the market participants and overall substitutability between market participants and their product. This also proved to be the case in the Zumbergs and Baltic mill merger case. And in the previous slide, it was already showed that this was the first ever failing firm defense case for Competition Council in Latvia. And basically the failing firm defense means that regardless of potential competitive issues of the same, some sort of the argument is made that the only alternative would be bankruptcy of the target business, and that this would be more harmful to competition than the proposed acquisition, as some of the or all of the target company's assets might leave the specific market. So to conclude this case review, nevertheless, the results and outcome of the carried analysis, it showed that this merger would significantly reduce the competition in this market. But this merger was approved as this case met all the preconditions of failing firm defense. Nevertheless, of the decision of the merger, the competition as I wanted to say, in this merger, if this merger would be prohibited, then the target company would have probably gone bankrupt, and there would be possibility that the assets of the company would leave the specific market and result in worse situation than this market in this market overall than it is now, as we allow the merger. So next slide, please. As for the future of economic analysis and mergers unit, we will continue to research and apply new analytical methods and increase our experience and knowledge. Also, a lot of cases are market specific, for example, telecommunications and TV providers. So we are planning to specialize our experts in different sectors to reduce the time it would take for an expert to become acquainted with the specifics of a particular industry, and also increase the accuracy of results and conclusions. Next slide, please. So that is the end of my presentation, and thanks to everyone for your attention.
Thank you very much to Mr. Perševics, Competition Council of Latvia, for bringing in the game the data perspective and possibilities of analysis, which is wrapped around the data use in competition and competition law. Thank you very much for all presenters of the first section. Now is the moment when we are switching over to the mode of questions and answers. And just a kind reminder, you can post your questions in the platform you are watching us, the Facebook platform, in the commentary field, and we're gonna take your questions here in the studio as much time as we have to take it. In the first section, we discussed the digital aspects of competition law, digital markets, and we had 4 speakers here just to remind what was the themes we are discussing here. EU Digital Market Act, one consideration how the field should self-regulate and how the game change is happening, shift in the way how we see how to regulate the big players in the field of digital market. Then there was a presentation on challenges applying competition law in digital market, already looking on the metrics, relevant market and assessment of its structure, how to assess and what are the rules of the game for the assessment. Then we heard the presentation on the role of economics in competition law with a bigger perspective. And the final presentation was in the first section about data, the evolution and use of economical analysis in the Competition Council of Latvia, with the practical merging examples and how the data were used during the merging examples. Well, now we are ready to jump on the questions, and we have several questions in the studio for the first section speakers, and here goes the question to Honorable Judge Colm Eochaidh. The first is, thank you very much, Mr. Eochaidh, for interesting presentation, the good words. And then, of course, the question, what is your opinion? Is there need to change the criteria for defining the definition of relevant market in respect to the digital markets? So the question on changes of definition of relevant market, is there need of such? Could you comment on this, please, Mr. Eochaidh?
It's a slightly political question, and therefore difficult enough for a judge to answer it. It's certainly been a real challenge for lawyers and judges to grapple with the concept of the relevant market. And yeah, anything that makes that easier is helpful. It is, however, difficult to engage in a priori market definition. And we have the rules that the case law has set out. It is sometimes very difficult to apply those rules to markets that are, if I can use the word, evanescent or just difficult to define. And I think as a general answer, and I'm sorry to avoid it, but the approach we see in the Digital Markets Act, which simply sets up rules where you don't have to define the market. In other words, you avoid that whole breach of competition law analysis. You instead have a set of rules that these very large companies have to abide by, whatever market they think they're in. So, yes, it's very hard to apply the rules and define markets in the digital world, and thus the benefit of the game-changing step which the Union has engaged in by adopting the Digital Markets Act. It's the first in the world, by the way. We are ahead of all major economies by having such a set of rules.
Thank you. Thank you very much for your answer here. The next question goes to Latvian Competition Authority. Thank you very much for your interesting presentations. Does Latvian Competition Council as a national competition authority sees for itself a role in regulating the gatekeepers? If yes, what be this role? If not, why? So your authority of Latvian Competition Council and the gatekeepers, the big players, how do you see this relevance for you? Who could answer to this from Latvian Competition Council?
I could try.
Okay.
So, in the level of Latvia, there is no such big platforms as Facebook and Google or Amazon, which would qualify as a gatekeeper. But as we know, the market is innovative. So, in a near future, there could be a platform also in a Latvian level that would qualify. But till then, we are, as a competition council, based on the Digital Markets Act, only giving our support to Commission when they will be carrying out some investigations on gatekeepers. But what can I say more about gatekeepers? Yeah, maybe in Latvia there are we can say that there is some platforms that could qualify as a gatekeeper, but not in the level of Digital Markets Act. For example, there are few strong platforms also in Latvia's level that are providing for suppliers access to the platform, and for buyers access to this platform. And because of these network effects, yes, there are just a few small platforms, for example, in e-commerce or in or few food delivery food delivery platforms that in some way works like a gatekeepers in Latvia level. So I hope I answered the question. Thank you.
Yes, you did indeed. Thank you very much. The next question goes again to Honorable Judge Eochaidh. The question is in Latvian, so I be a bit clumsy in translation process, so excuse me for that. The question is on the mindset of the big players or game changers. Mr. Eochaidh mentioned that self-regulation is in the core of this legislation. Are the big players ready, honestly, to self-regulate them? So that would be the question about self-regulation and the mindset of big companies. Maybe you can share your expertise and feeling on this.
Well, self-regulation, well, I'm not sure if I used that phrase. If I did, I should explain it isn't self-regulation in the normal way. It's more that the Digital Markets Act defines what is a gatekeeper, and companies must read the rules and ask, am I a gatekeeper? And if they are, tell the Commission. So in that sense, they must self-identify. If they don't, the Commission is given the power in the Act to conduct market investigations and identify people who are gatekeepers. So the key thing here is the rules contained in the Digital Marketing Act, all the do's and don'ts, the things they are required to do, the things they are prohibited from doing. These are not self-regulated. Those are policed by the European Commission. And so the Commission remains an investigator and an enforcer of those rules. And of course, every individual consumer can enforce the rules in their national courts by saying the rules which apply to these big companies have been breached. So the only part of it that is self-regulating, as it were, it's really better described as self-identifying. Because of course, as a general principle, one wouldn't leave companies with such huge market power the pure ability just to regulate themselves. That's not the way the union works. It's not the way national governments work. These companies must be regulated, or they do, as I said in the beginning of my talk, companies all tend to monopolistic behavior, especially those in dominant positions. So no, the heart of this Digital Markets Act is not self-regulation, but a tipping point in it is self-identifying.
Clarifying this concept and self-identification within the self-regulation motif. Thank you very much. There is also a question to Mr. Przansky, but this question, I believe, will be answered in the presentation in the next session. Mr. Przansky will give, because the question is about damage in practice, and how to estimate damage in practice is your presentation in the next section. So we're going to skip this question now. And we are finishing our Q&A session. Thank you very much indeed for your time and possibility to be here in the conference on competition law. Thank you for all speakers of first section. Have a nice day. And dear audience, we are going now in a short 5 minutes break. So we have a 5 minutes break. You can fill your cup of coffee. We're going to do the same here in the studio and see each other in 5 minutes.
Thank you very much.
Well, good afternoon, dear ladies and gentlemen, dear audience. It's indeed afternoon already. We had very informative and intense the first part of the day in a conference on competition law. Just a reminder, organized by University of Latvia Faculty of Law and in a deep cooperation with Rodel and partner. We are in the second section now, actions for damages for infringements of competition law. And this session, after all the speakers, will be concluded with a panel discussion. Also within the panel discussion, we will take in your questions and comments. So we are continuing our tradition of today that you are posting your questions and comments in the commentary field of the platform. You're watching us, the Facebook most probably, and then we're going to deliver your questions and comments here in the studio. Time frame is pretty intense. I wish luck to all of the speakers, and my pleasure to start with giving the floor to Professor Dr. Justus Haukapp, University of Düsseldorf, the Economics of Antitrust Damages. Professor, the floor is yours.
Yes, thanks very much. I'm not entirely sure whether I have prepared some slides, whether I am sort of showing them or you are showing the slides.
We are showing the slides.
You are showing the slides, perfectly. Mm-hmm. So let me just start. So the economics of antitrust damages. Let me start with speculating a bit about the motives. Why do we need antitrust damages at all? Given that it's a, let's say, fairly recent development that also damages play a much larger role. So if you go to the next slide, from an economics perspective, you would think, okay, the first idea is that you want to deter further cartelization or antitrust violations of antitrust law. So in that sense, damages help because they are something else that the violators take into account and should deter them from engaging in antitrust violations. But of course, that's not the only motive, because this motive could simply be fulfilled by just increasing the fines. Actually, and we would reach that goal probably much easier than having private plaintiffs suing for damages. So a second idea, and I think this is what, to my understanding at least, this motivates also private damages in the US to some degree, is that we say we want to have private parties helping us in some sense in detecting antitrust violations. That means if you are able to sue for damages, your incentive to, let's say, detect a cartel or to detect an antitrust violation may increase. But then in Europe, private enforcement only plays a secondary role, really, in antitrust. Most is enforcement by the competition authorities. So it's quite different from the US, where private enforcement plays a much harder role, and therefore damages may play a harder role by sort of stimulating incentives to detect antitrust violations. And if we read through the directives, we see clearly in Europe there's also some, I would call it, distributional concern, or let's say fairness concern, in that sense that we say those that have been harmed by a cartel should be compensated for the harm that has been done to them. So the idea is that these cartels or these antitrust violations or those who have been sort of hit by antitrust violations actually get their money back, so to say, or that the damage is undone as far as possible. So there's this distributional fairness concern that comes along. So in the end, I would think it's a mix of both. Yes, we want to strengthen the effectiveness of antitrust enforcement by awarding damages, but we also want to have some sort of compensation for those that have been harmed. So the European directives then say, ask sort of who can claim compensation, and at least in theory, or I would say in theory, everybody that has been harmed can sue for compensation. And who is everybody? Of course, if you go to the next slide, we see everybody first of all, of course, these are the parties who have bought, or let's assume that's a cartel of suppliers, So these are people who have bought something off the cartel to possibly too high prices. Yeah, so these are the direct customers and possibly also the direct potential customers, because if cartels really lead to higher prices, there are always some people who stop to buy because it's getting too expensive. So at least in theory, there could be people who have not bought from the cartel but would have bought if they had charged a competitive price. Of course, this is something that is close to impossible to prove, I think, that you would have bought something if the price had only been lower, but you didn't buy because the price was too high. So I haven't seen any cases where really somebody who has not bought from the cartel has claimed the damage because he didn't buy because the price was too high. But in theory, in economic theory, you'd say, okay, these are people who have been harmed by the cartel. The same applies to indirect, of course, buyers. These are buyers, let's say there's a cartel who sells to a retailer and the retailer sells on to somebody else, then of course the people who have indirectly been harmed by the buyer because they have bought for too high prices from the retailer because the retailer may have passed on the price. And again, there may have been potential customers who have not bought from the retailer because the price was too high. And then we can move on and actually ask, aren't there not even possibly even more people who have been harmed by the cartel? Yeah, and we say, well, actually, yeah, there may even be people who have not been bought from the cartel, but by cartel outsiders. Often we have cartels who may not encompass the entire markets. So we had a cartel, for example, in liquid gas in Germany, where part of the market was cartelized, but not all of the parties participated in the cartel. And then we run into the issue of umbrella pricing or umbrella effects, and then there may be people who have bought from a not cartelized firm, but the not cartelized firm may have been able to charge a higher price because there was a cartel in the market. And of course, this is something that's also very, very difficult to prove. But in economic theory, you would say this is somebody who has been harmed by the cartel, actually. And then there are actually also firms that supply to the cartel. And at least if we look at economic theory again, let's say, what do cartels typically do? They increase the price. That typically means there's less demand for the product. And there's less demand for the product, you need fewer inputs, typically. So the suppliers may have been harmed because they couldn't sell as much as they would have been able to sell if there hadn't been a cartel in the market. And the same applies to employees, even if cartels really reach quantity restrictions because not enough has been sold or not as much as in the competitive market. You say, well, probably they employ fewer people than they would have if there had been competition in the market. So in theory, you could even make the case that employees or the people who have not been employed actually may have been harmed by cartelization in the market, because typically competitive market leads to market expansion, more people participate in the market, more people being employed. So in theory, you could say even those can be harmed. And we can actually move on and say, well, there can actually also be suppliers of complementary products who may have been harmed. Because if you're selling a complementary product, let's say there's hardware and software, then if there's a cartel between hardware suppliers, that means hardware gets more expensive. That means people buy less software, of course. Or if we look at the classical example of fuel and cars, if cars are more expensive, people buy fewer cars. Then they need less fuel. So the fuel producing companies may be harmed by a cartel in the automobile sector. So if you think about complementarities, it gets even worse in the sense that we can expand sort of the set of or the number of people who may have been harmed by the cartel to quite a large number. Actually. And then we can even think about competitors who may sometimes be harmed, probably not so much in the case of horizontal cartels, where typically you benefit as a competitor because you also can charge higher prices even though you're not part of the cartel. But in vertical relations, if there's a vertical antitrust violation, also these people may be harmed. So then the question becomes, okay, in reality, what we see, or all of the cases that I know about, we really focus only typically on direct customers, sometimes the indirect customers. So the good idea is that everybody could be compensated. I think in reality, it's close to impossible, actually, to compensate everybody. So we focus on those that maybe suffer the greatest harm, and these are typically the direct customers of the cartel. And how do we do this? So without sort of going into all the details that I assume Mr. Prujansky will elaborate on, let me just make a few remarks. And maybe I, given the limited time, I jump a bit ahead and sort of we know sort of the gold standard that we want to apply is so-called difference analysis. So we look what happened before the cartel was formed, what happened during the cartel period, and what happened after the cartel terminated, and then compare this to a market where we didn't have a cartel and look how did the difference between the prices develop, and is there a difference between the differences? Actually, and I assume Mr. Prujansky will elaborate on this, so I jump sort of over this point, but maybe just jump ahead if you sort of move on, let's say, 3 more slides, actually, and we ask ourselves, so how do we actually calculate, what's the practical complication in calculating the cartel damages? We will see that very often, at least that's my experience, also data from the period before a cartel is often not available in practice. It's too long ago, so typically you have to compare something during the cartel time and after the cartel time. Then, even if we have data from the time before the cartel, we are often not entirely sure when did the cartel really start. Yeah, the competition authorities typically have a finding, something that say we are really sure that the cartel has existed since at least year XY. Yeah, but possibly it has existed before. We are not entirely sure. Yeah, so we don't really make a statement about it. But that, of course, from an economic perspective, makes it difficult to just take the data from the time before, because possibly you just compare the time of cartelization with another time of cartelization. So my experience in practice, data from time before the cartel doesn't really play a role. Data after the cartel period is often available, but then it depends again how long, how much data do we actually have from the time? Yeah, how fast can you bring your litigation? And often, if it's sort of too fast, you don't have a lot of data. And then, of course, behavior of cartel participants directly after the cartel may not reflect what would have happened without the cartel. So very often, sort of, you have some sort of during-after approach, and that is even difficult in a sense. And the second question that emerges is, where do we get the data from? So if we move to the next slides, and here my experience has been that often the cartelists, the defendants, have access to much better data than the litigants. So if you are a firm that buys something from a cartel, you are just one firm and you have maybe bought a product during the cartel time and after the cartel time, but it's just you, actually. While the cartelist typically has data from all the people or all the firms that they sold to, and they may have been active in different markets, also across Europe, so they may even be able to compare that to other markets. They have much better data, of course, also about the cost of production, naturally, yeah, because they are the producers of the product. So for the litigants or the firms that have potentially been harmed by a cartel, is typically much more difficult, actually, to obtain data and to sort of elaborate and to develop similarly good calculations as the defendants can actually do. So I think actually there's an asymmetry in the weapons, so to say. Yeah, the defendants have access to reasonably good data, while typically the claimants or litigants have access to not such good data in many situations. And I think this brings us to some degree to the question, what can we do about it? Actually, is there anything we can do about it? Given also the situation that the courts, and I'm very anxious to hear what the judges have to say. They have to deal with all these expert opinions that come into the court, and what my experience is typically the defendants in very many of these cases come with very elaborate econometric studies that show that there is no damage. and the litigants typically come with sometimes not as elaborate, but also elaborate econometric studies that show that there is a damage. So as a judge or as a court, you have to come to a conclusion in the end. So what you typically do is that you try to hire some court expert who's independent, if there's anybody left in the market for economic experts, so to say. Yeah, and then sort of my suggestion would be, first of all, these economic experts should have a close look at all the economic documents that have been provided, including all the data that has been used by the parties. And this is something that we know from scientific practice. If you submit an economic article, an empirical economic article to a good journal, you have to provide all the data, the raw data, also to the journal, so that the referees can actually evaluate whether you have sort of done the proper calculation, whether you have left something out, whether there are small mistakes. Mistakes can always happen, actually, so that they can do a rough check directly in the beginning. Yeah, and once you have done this, yeah, you can of course ask the question, maybe you do your own calculation as an economic expert. If we move to the this is the last slide, given the time limitation of 15 minutes. What can we do? Yeah, I think there are two ideas. I think I must say I'm sympathetic to the idea of shifting the default option, so to say, away from 0% damage to something of a damage of 10% or 15% or say. Why is this from an economic perspective? I think this would give the defendants, the cartelists, a high incentive so if this is a rebuttable presumption, this 10 or 15% damage, to provide data to prove that in their particular case damage has been lower than the 10 or 15%. If the rebuttable presumption is 0%, typically the defendants don't have very strong incentive to provide the good data that they typically have. So I think we have to. We could consider that it makes sense actually to shift this rebuttable presumption a little bit sort of in favor of the parties that have been harmed by the cartel, because they don't have access to the sort of good data. So for them, it's much more difficult to rebut the presumption than it is for the defendants, who have access to better data, who have it easier to rebut actually this presumption. I think that's the reason why I'm sympathetic to shifting this sort of default option away from 0% to something like 10% or 15%, as some countries, and I understand Latvia, have done. I could also imagine that competition authorities, as a second sort of option, get a little bit more involved into cartel damage estimation, not maybe being a part to the court or so on, but when they know a lot about the cartel typically at hand. So if they could give a rough first estimate in the sense of, is it a low, medium, or high damage that they expect, and sort of shift the rebuttable presumption away from 0 to something else, actually. And my maybe naive opinion is that since they know a lot about the cartel anyway, it should be not too difficult for them to give a small indication, at least what they think about the damage in this particular case. And I leave it here. I think I've used 18 minutes according to my watch. So apologize, please, and I'm looking forward to the next presentations.
Thank you very much, Professor. We forgive you those 3 minutes. That's okay. We're going to take it within the panel discussion. We're going to compensate this time. Thank you very much for a very informative and at the same time already questions opening presentation. And we are moving forward now with the next our speaker on the issue of damages claims, Judge Inga Reine, General Court of the European Union. So, Madam Judge, the floor is yours.
Thank you. I hope you hear me well.
Yes, we see you well and we hear you also.
Okay, I will try to gallop here through the presentation concerning this complex subject, I must say. I am actually very happy to speak after my dear colleague Colm and also Professor Halkap, because that would save me a moment in maybe explaining some basic things, and I will build upon some of things that they have already mentioned. Maybe let's leave the discussion about expertise during the judicial procedure for the panel discussion, because this in itself is a very interesting subject to be discussed. I will not address it. What I will do, I will touch upon different issues related to the compensation of damages. Let's use it this term in a broader sense. And I will also address some of the aspects that have not been mentioned today, just to show again the diversity and the complexity of the issue. Next slide, please. So in essence, I will try to show you four different aspects of four different elements pertinent to this discussion. And first, I would like to draw your attention to the quickly evolving, we have to use that term in the context of judicial proceedings, but to the evolving debate about default interest. This is an issue in itself when it relates to antitrust law, because in essence, at the bottom of the pyramid is always an administrative decision imposing a fine, be it by the national authority or the commission, and I will look at the jurisprudence of our two courts, of the European courts, to show how it has been evolving before us. And that is the primary debate, that following an administrative decision, which is fully or partly annulled, there is a reverse claim against the authority for the default interest related to fine. Then there are claims, of course, there are claims for non-contractual liability for various types of actions and decisions. Then there are private enforcement mechanisms. Some of those elements have already been mentioned. These would then be claims by the parties against the participants of the cartel for the damages caused. And then I would like, if there is any time left, I would like to show you the a couple of procedural aspects related to those claims that should not be forgotten about. Next slide. The first thing that I would like to mention would be the discussion about the default interest that shall or shall not be paid following the full or partial annulments of fines imposed in this particular case by the Commission. But then, of course, there is an entire debate of how this jurisprudence would be transposable to the discussions with national authorities of member states. Next slide. And the first and most important case from the recent jurisprudence, of course, you might have already heard of it. This is Primacy's case, which is the first time where the court had to address the issue of a claim under Article 266 of the Treaty on the Functioning of the European Union, whether the Commission should pay default interest on the fine following a decision annulling the fine imposed for the antitrust violation. And the essence of this claim and the debate before the judicial authority, of course, was the fact that following a violation, because in that particular case, a violation of rights of a private company that was fined for competition law violation, was the essence of restitutio integrum, meaning that the situation must be restored to the facts as they were before the violation took place. And this is the principle that also governs, maybe to build upon of what Professor Halkap said, this is also the same principle that governs the private enforcement mechanism when
private parties seek compensation for damages. It's always this legal principle of restitutio in integrum when we speak of violation of some rights. Next slide, please. So what the court said, the Court of Justice in that particular case said in that landmark judgment is, first of all, and you may, I hope, that you are aware of the fact that the specifics of the EU antitrust regulation, when the commissions are imposing fines, that fines must be paid right front, and then the company may challenge the administrative decision of the commission, but the fine must be paid right away. And then, of course, the question arises when and if the fine is being fully or partially annulled by the General Court, by the Court of the European Union, then the Commission pays back the difference, or the full or the difference in the amount of fine. And Printers brought a claim against the Commission saying, well, not only that the fine must be paid back, but also the default interest on that fine, because the Commission withheld that fine for a number of years. And that means that that money was sitting somewhere on the Commission's account, and probably also given some profit from that money. So there were three basic elements to that debate. That first of all, apart from the fact that the fine itself should be returned to the company, the Court of Justice said that on that fine, on the difference of that fine that was paid, well, in Printer's case, that was the full fine, that there are default interests that should be calculated on the same rate as it would have been calculated for the company itself had it been late with the payment of fines. So this is the same rate of 3.5% on top of the rate established by the ECB, deriving from the regulation, from the delegated regulation of 2002. And that what is most importantly is that if there is a delay in returning that amount of fine, that there must be also a compound interest paid on top of that interest rate. Next slide, please. Why the court decided to do so? And that was an important part of the reasoning, that in the court's view, of course, the principal purpose of the fine, of the default interest for the commission was that one must be compensated for the violation. And in order to comply with the judgment. So this is going back to the same principle of restitutio in integrum, because money loses its value. So not only the money, the factual amount must be paid back, but also the added value of that money, or the loss of value of that money, must be compensated. The second element, which was very important in terms of reasoning, that this default interest is also having another purpose, and that is an incentive for the institution concerned to think twice, if I may use the plain language, when adopting decisions. So that is a way to also prevent the administrative authority, in this particular case, the European Commission, from imposing exaggerated fines and from paying due attention to the facts of the case. And the third element, because there was a debate, and that debate is not over, I will show you an evolving jurisprudence. There was a direct reply, literal reply to the argument of the Commission that it has room for maneuver, as it says, the discretionary powers to decide what kind of interest rates to be established on the payment of, on return of the fine. And the court said that on that particular aspect, the Commission does not have any discretionary powers. And then default interest should be established equally both directions. So it's the same interest that the company would pay in case of late payment of the fine. The same principle should apply with respect to the European Commission when returning the fine. Another important aspect of this judgment is that when we speak about the default interest, the Commission argued that, well, sometimes the investment of that money yields higher percent, sometimes the investment of that money yields lower percent of return. And that issue also was addressed by the judgment. Yes, the average reference point is the reference point established in the regulation 1268, but there is also an important clarification in that judgment that if the yielded interest is below or equal to the percentage rate established by the regulation 1268, then it is the rate applicable mentioned in that regulation. But if the return on that investment is higher, then the default interest should be the de facto default interest, return interest on that investment fund. So that is the overall context of that important jurisprudence. And now if we move to the next slide. That jurisprudence produced a follow-up case. And again, just to recall the importance of the Pinter's judgment, in Pinter's case, the General Court annulled fully the decision of the European Commission in the previous litigation. In the Deutsche Telekom case, a recent case, it's a judgment this year, it was another claim for compensation of default interest, another debate with the European Commission, which went back to the case where the General Court, in its first litigation, announced the Commission's decision only partially. And that was the debate then between the applicant, Deutsche Telekom, and the Commission, whether in this situation where the court acted in full jurisdiction in reviewing the fine, whether that situation produces the obligation to pay default interest, and what would be the departure date for calculating those default interests, because the court replaced the Commission's decision with its own decision acting in full jurisdiction, in plain jurisdiction, and what would then be the amount to be paid. The applicant, Deutsche Telekom, presented two alternative claims because, again, that was not entirely clear how to address the situation. It was the claim under the either a principal claim for non-contractual liability under Article 340 of the TFEU, or alternatively, going back to the same line of thinking as Pinter's, a claim under 266, which gives the right to claim default interest for the delayed payment. Next slide. Yes. So the principal argument in this case for the European Commission was A, the Commission did not know that the decision would be annulled. B, it was annulled by the General Court. C, the new fine was imposed by the General Court, and therefore the Commission should not be liable for any interest unless that interest derives from the delayed execution of the General Court's judgment, which wasn't the case because the amount of the difference in fine was quickly returned by the European Commission following the judgment of the General Court. Next slide. So what the General Court said in that particular case, that for the claim, for the principal claim for the non-contractual liability of the European Commission in imposing the wrong fine, and the debate that if that amount was kept by the company, it would have been invested in other projects. The General Court replied that there is a lack of strong causal link between the claim and the damage, between the damage and the responsibility of the European Commission, because yes, of course, we can all presume that this money could have been invested elsewhere, but there were no strong, convincing economic data available from the part of the applicant to show that causal link between the money that was paid and fine, invested in paying the fine, and the possibility and probability of that money being invested in any project. Because there was a claim, there was a good estimate of how much money was involved, but there was very little done for the explanation of how high was the probability of that money going into concrete projects. Next slide. However, when it comes to Article 266 claim, and that is the obligation to pay the default interest, that claim was admitted, and the Commission decision was annulled, rejecting the payment of default interest. And there were specific reasons. The General Court, of course, replied to the Commission's argument why it was wrong in claiming that it had no obligation to pay default interest. And first of all, it drew attention to the fact that the annulment of the Commission's decision by the judgment of the General Court has retroactive effect. So once the General Court annuls, that annulment dates back to the day of the adoption of the decision. The exercise of the full jurisdiction of the court, and that was the particular argument on which the Commission insisted, that the moment, the very fact that the court exercises full jurisdiction relieves the Commission from any obligation to pay any default interest. Again, the court replied that this exercise of full jurisdiction and the placement of the fine dates back to the very same moment when the Commission adopted its contested decision. So one way or the other way, the obligation to pay a certain amount dates back to the adoption of the decision, and hence the difference in payment then starts being calculated dating back from that moment, also then producing the obligation to pay default interest. Next slide. This judgment has been appealed against for understandable reasons, and I give you the reference case. Now it is pending before the Court of Justice, so we're yet to see whether this reasoning of the European Commission, of the General Court is going to be upheld. But again, this is a spoiler for you to follow on the case. Next slide. Why this jurisprudence is very important, because you may have followed, if you followed the evolving jurisprudence, especially in antitrust law, you would certainly have heard of big cases that have just been completed and still cases which are in the process. And one of the most recent judgments, of course, we have Google judgment, we have Intel judgment. And recently, these Google and Intel judgments are still under appeal before the Court of Justice. But for the very recent judgment, we have already the claims, new claims for the default interest. And if you remember, maybe the first round of debate of the air cargo capital, the famous air cargo capital case, where the first round of debate is already over when the fines were reduced by the General Court. And now we have a follow-up claim from 4 of the air companies claiming default interest for the difference in the amount. And if you see the amounts of claims are important enough, it's between 14 and 57 million, which is being claimed in default interest. what is interesting in those cases that, of course, first of all, it would be a continuation of the debate following Deutsche Telekom, because these fines were reduced and not fully annulled. And second, in these claims, if you now try to remember the history of these cases, that we're going back to the beginning of 2000, the investigation, that the Commission is raising the argument that these claims are time barred, because the events took place so long ago that the company should no longer have the right to raise a claim for compensation and raise a claim for default interest. So this is indeed an interesting jurisprudence to follow up. Next slide. Then we have a second part of that debate, claim for compensation under Article 340, again, from companies following up the decisions of the European Commission. Next slide. And one of the most important jurisprudence, recent jurisprudence that I could mention in that respect, are the joint cases UPS and ASL. And this is the merger case, for those of you maybe who haven't followed the debate. And again, that case goes back to the Commission's decision blocking the merger of the parcel services, where UPS was trying to acquire TNT. And that merger was blocked by the European Commission. And later, that decision was annulled by the General Court, and the decision was upheld by the Court of Justice for the lack of violation of the right, for the violation of the right of defense of UPS. ASL had a contract with UPS with many rights and obligations conditioned on that merger. So what happened following that first round of litigation? That UPS, in the meantime, abandoned the merger because partially what was claimed by UPS itself, for the reasons of the length of proceedings that were necessary to contest the decision, and their specific situation, going a little bit to the background of the case, that of course they had a number of investors sitting in the pipeline waiting for the merger, and when that merger was blocked by the European Commission, the investors simply dropped out. So they no longer had sufficient interest in bringing the action forward. So following that unlawful blockade of the merger by the European Commission, UPS and ASL brought a claim for compensation of damages against the European Commission. Next slide. What happened in that present case? And of course, this is an important jurisprudence building up on the jurisprudence of Schneider, which was widely debated at the time. The court recalled the three necessary conditions. First of all, that there must be a rule of law infringed, that the breach must be sufficiently serious, and there must be a direct causal link between the violation and the damage caused. Next slide. In the case of UPS, the General Court admitted that the previous jurisprudence, the previous litigation between UPS and the Commission established a sufficient infringement of the UPS's right of defense. So that violation was clear. Second, the General Court recognized that this was a type of violation, given the particularity of the case, which is sufficiently serious that would qualify for being the type of breach that would give rise to a claim for damage. Next slide. However, when it came to the establishment of the causal link between the violation of the rights and the damage caused, the General Court followed the classical jurisprudence, the jurisprudence that already exists, in failing to find a causal link. And again, here comes the whole question of the economic model and economic estimates and establishment of the link. But one of the particular elements which played a role, and this is again why I recall the jurisprudence of Schneider, that is the question of free will. And this is, I know, a very deep debated issue, whether the drop of merger, the giving up on the merger is in essence, and to which extent this is an expression of a free will or an economic necessity. There was a debate in this case, but in this particular case, the General Court was not convinced by the arguments of the UPS that it was an economic necessity, that there was no question of choice, and it stuck to the classical jurisprudence that the merger was abandoned by the company upon its own free will, and therefore the causal link was broken by that mere fact. Next slide. The ASL action for damages was also rejected for the reason that it did not directly participate in the merger, and it could not really establish again its proper claim vis-a-vis the European Commission, simply based on the violation of the right of UPS. We're waiting for the appeal. This judgment is still under appeal. I have checked yesterday, haven't seen yet any indication whether an appeal has been lodged, but I would not be surprised that there is an appeal against this judgment. This is an important judgment, an important debate, which most probably will continue before the Court of Justice. Next slide, please. Then I come to the next debate on next element in this debate, and this is the private enforcement. And this is where I come again to the interest of private parties to bring claims against members of cartels and members of companies that have violated competition law. Next slide. And here we have an important instrument that was adopted in 2014. You are all aware of it. This is the Directive on Actions for Damages for Breaches of EU Competition Law. And that Article 3 of that directive builds upon well-established jurisprudence of the Court of Justice, establishing the three elements, three aspects for which compensation may be claimed. This is actual damage, this is loss of profit, and this is payment of interest. Next slide. Since the adoption of this directive, there have been 6 judgments of the Court of Justice, some of them on appeal, some of them for preliminary rulings. Well, I give you the preliminary rulings statistics, where the conclusions contained in the judgments are directly pertinent to the interpretation of the directive. I am not using the term that they are interpreting the directive for the very good reason that most of those judgments relate to the fact predating the adoption of the directive. But what the conclusions contained in those judgments are directly relevant for the interpretation of the 2014 directive. Next slide. What is even more interesting that since the adoption of the directive, for the first time in history, the EFTA Court has delivered 2 opinions on issues related to the private enforcement of antitrust rules. So for those of you interested in that, please follow up on those judgments. Next slide. Now, the most maybe important recent jurisprudence in the area of private enforcement, this is the last November judgment in the stitching cartel case. And it is important just for you to maybe recall the complexity of this whole situation, because this is what we call the very famous cargo cartel case. And I have just mentioned the saga related to the default interest before the air cargo companies and the European Commission related to the first round of that debate. Now, the second aspect of dating back to the first round of that debate is the stitching cartel case, where in parallel to the litigation between the air cargo companies and the European Commission for the imposed fines, private parties lodged claims for damages before national courts. And in that particular case, that was the Court of the Netherlands. And in that particular case, the Court of Netherlands had to look into issues predating the directive and, attention, predating the 2003 regulation itself. So that debate, and again, going back to what Judge Miķelis mentioned, that if you imagine the length of proceedings related to the antitrust investigation, this is the timeline of the case that dates back to the traditional period predating the 2003 regulation. Next slide. And in that particular case, was the question whether national court had jurisdiction to look into private claims arising out of violation of EU antitrust law, and whether there was a conflicting jurisdiction with the European Commission. What the court said in that case is that the national court in that particular situation directly applied the European treaties, and of course they were under obligation to ensure full effect to Article 101 of the treaty, and in particular that there was no affectation, there was no risk of overlap or conflicting judgments before the national court and the European Commission. Next slide, please. The Court of Justice said yes, certainly the competence of the national court would be limited by the principle of legal certainty, but since the facts of the case go back to the transitional period predating the adoption of the regulation of 2003, this is not the case. The risk is not there for two reasons. First, the Commission could not act during that period of the transition, and second, the regulation 2003 itself does not have retroactive effect. So for that reason, national courts do have competence to look into this claim. Of course, the following issue is that, again, please remember that we're speaking about the late 90s, beginning of 2000s, where the violation or the cartel was established and affected the rights of private parties. Now, of course, the whole situation is closely linked not only to the fact that this is a transitional period, national courts are competent, but then the following question arises, which are the time prescription, the prescription for raising those claims. And I will show you one judgment which would be of relevance. Then there are some other judgments which are, of course, pertinent to this debate. And one of it, next slide, please, is Skanska judgment, which is a bit older judgment that dates back to 2019. But this judgment is important because it goes back to the fact of inheriting the obligation to pay compensation, because again, time goes by, companies are being divided and acquired, there are different mergers, and Skanska establishes an important principle that also the legal successor of the previous company inherits the obligation to pay damages. Next slide. Cogeco judgment, also may be known to a number of you, established the next important principle in framing this obligation to pay compensation, that, of course, limitation period, and that was an important conclusion in that, even if for some issues the directive is not applicable ratione temporis, still national law must provide for effective right of victims to claim damages for the compensation.
Honorable Judge, our time is running out.
Yes, I will give you just 5 more minutes. I will complete, and then I will have a shorter presentation for the second subject. Next slide, please. Otis judgment is also very important in terms of establishing the rule not only private parties can claim compensation of damages, but also public entities can claim compensation of damages and return of the amount paid to member of cartels in violation of the EU rules. And then it brings me to the concluding part of that. If you could give me next slide. What I wanted to show you is the procedural nuances for raising those claims. Next slide, please. And the following slides, which I will show you very briefly, show the link, because we all know, as Professor Haukat mentioned, more or less everyone can bring a claim of everyone, and we have had an evolving jurisprudence of who can claim damages, for which period it can be claimed. We have established the fact that the deadlines for raising the claim must be sufficiently effective. But then an important aspect is where to bring this claim. And there you have the 3 judgments, and I will bring them in one. You will find them in the slide. You have Laila, then the following judgment. Next slide, please. Apple sales. Next slide. Tribor Trans. And the last slide is Vikingerhof judgment, which show the link between the antitrust rule and the regulation on jurisdiction and recognition and enforcement of judgment. Because this regulation comes into play in determining the place where the claim of damage may be brought. It doesn't mean that the claim of damage must be brought in the domicile of the company. Of course, there is an issue of the location of the company itself, but then this is not the only possibility to bring that claim. There has been jurisprudence in the slides, you will see them, that it can also be brought in the place where the results, the effects of that violation were felt. That was either the place of the performance of the contract or the place of the performance of the services. And the last case, the Kingerhof, which is very interesting, is in itself where a company, a German company, brought a claim against Booking.com, which is a company established under Dutch law. And in that particular case, the applicant sought before the German courts a recognition of the fact that Booking.com has violated competition rules. So it's not only for the claims of damages where the regulation on jurisdiction and enforcement of judgment comes into play, but it is also for the mere fact of the establishment of a violation of the competition law. And German law allows to do so, and this is how the Court of Justice recognized the jurisdiction of the German court to do so. And that subsequently, if that violation is found by the German court, of course, that gives the applicant the right to claim compensation. Final slide, please. So what conclusion can I give you? You see that the jurisprudence is evolving to touch upon different corners of the litigation related to the antitrust. What remains a big issue, and again, I will repeat again the conclusion, the comments by Colm, that this, of course, is all overshadowed by the length of proceedings related to antitrust and the whole debate when we bring back the claims for damages of efficient rules for time barring the claims or for recognizing those claims. And Cogeco judgment in that respect is important, that regardless of the fact whether the directive is applicable or not, the claim must be, there must be an effective time span for the applicant to bring that claim. And what is important in that context is not only that there is a time period, but also that that time period is subject to suspension and prorogation, because this time period is intrinsically linked to the administrative procedure in antitrust that significantly affects the framework, the substance of the rights and obligations of the parties. And of course, we are yet to see the evolution of the debate related to evidences and to causal link and perhaps the divergent practice between member states. Thank you. That will be all for me now.
Thank you, Honorable Judge Madam Reine. And we are continuing our section here with the next speaker, who is already the second time today, and with his speech definitely going to answer also the questions from the first section. I'm speaking here on Mr. Vitaly Pruzhansky, RBB Economics from Brussels, how to estimate damage, this time in practice. So, Mr. Pruzhansky, the floor is yours.
Yeah, good afternoon, everybody. Well, I think at the outset, I would like to make two remarks. First of all, when you talk about estimation of damage, you have to acknowledge the importance of this procedure for all parties involved. So it is actually both a sword and a shield. It could be used as a weapon and could be used as a means of defense. So it's important for claimants and important for defenders. That's number one. And number two, we probably will be talking a lot about cartel damages today, but one has to acknowledge that this concept should apply much more broadly. And in principle, you can also think about estimation of damages from abuse of dominance cases or from cases involving unfair competition. So really, there is a variety of situations where you tend to apply essentially the same economic tools and the same economic frameworks, maybe with minor adjustments. Now, moving on to the practical application of all that, it probably goes without saying that if you estimate damage, you have to deal with a lot of empirical data. You may need to employ sophisticated statistical techniques. There is a lot of number crunching, and well, basically this cannot be done without economists. For better or worse, economists will need to be involved. Now, there are three main effects when you talk about damages, and it makes sense to sort of talk a little bit about this, about these fundamentals. The first effect that you need to estimate is what economists call overcharge. Essentially, it asks the question, by how much has cartel increased prices? This is not a straightforward question because there could be many products involved. For some of them, the price increase may be 1%, for some overcharge maybe 50%, so you have to deal with all these issues. In some countries, like in Latvia, there is a rebuttable presumption about 10% overcharge. Of course, presumptions like this have to be rebuttable presumptions, and one has to be very careful about them. But it's good that complainants at least have something to start with, and it's a useful starting point. Now, how you go about estimating overcharge in practice, put simply, you need to think about counterfactual, you need to think about what might have happened on the market but for infringement or but for cartel, and that means that you essentially need to find the right benchmark to compare prices. And, you could look at prices before a cartel was formed or prices that, resulted after the cartel was dissolved. You may have to, you could get some sense of the overcharge from this. You can also look at the dynamics of prices in similar products or in similar or neighboring markets. You can look at, how prices evolved there. Importantly, those benchmarks should not be affected by the cartel because otherwise they would not be valid. So this is something you need to take into account. And you will need to worry about factors which may distort such comparisons. For instance, oil prices may increase due to inflation or to other factors which are completely unrelated to cartels. So again, you need to apply a range of analytical tools in order to to arrive at the correct estimate, take all this into account. Now, once you've estimated overcharge, you need to go further, and overcharge is not everything. Just to give a very simple example, imagine you purchase 100 units of some product from a cartel members, and you correctly estimate that cartelists have increased prices by 10 euros above the competitive level. So in principle, you could think that your damage equals to 1,000. You bought 100 units and 10 euro was the overcharge. But that's not how you should do it because of the effect which economists call pass on. And the idea here is very simple and intuitive. What do you do if your costs increase? If you're a rational firm, a rational economic agent, if you experience an increase in costs, you would be incentivized to pass on some of these cost increase and increase your prices. And that means that there is some compensation that you're getting. The devil is in details, because then the question is how much. Maybe your prices have increased due to overcharge, or maybe they increased for some other reasons which are completely unrelated. And you have to sort these effects out. It is especially challenging to estimate such effects when price changes are small. Just to give an example, think of, let's say, our firm. We're a large economic consultancy. We have pretty high turnover. We do a lot of work, but we may purchase, let's say, coffee creamers, something very small, very cheap. And if there was a cartel among producers of coffee creamers and they will increase their prices by 10 or 20% in relation to our fees, that price increase would have been minuscule. And the question, how do you actually measure these things in reality? How do you measure a general increase in our prices and distinguish it from market-driven effects and from small changes in cost that we experience as well. And that may be that simple. And one trick here that you could employ is just general understand how companies pass on costs from a historical perspective, and maybe use some benchmarks that to predict what might happen if cost increase is actually very small. One other area when you need to worry about speaking about pass on is distinguish between changes in variable costs and fixed costs. Again, economic theory gives us different answers as to how much pass on you could be expecting to get in these situations. So that's something that you need to consider. There are lots of conceptual pieces when it comes to pass on. For those who are interested, I think it would be advisable to read the decision of Competition Appeals Tribunal in the MasterCard Sainsbury case in the UK, which raised a lot of interesting discussions about what pass-on is and how you measure it. And one of the issues was, for instance, the following. What if the overcharge is absorbed, not passed on, but is absorbed by making cost saving elsewhere, especially if there is a clear causal relationship between the two? For instance, there is a sweet shop which buys sweets wholesale, and that shop may experience cost increase, but instead of raising its own prices, it, for instance, reduces its marketing budget or starts paying lower wages to its staff. Is this pass-on? Can you call such a situation pass-on? And there are lots of conceptual questions related to this. Again, I would refer to this judgment for those who are interested, but I think what's important for us is that in the context of the judgment, I think one interesting idea was that if there is pass-on, you need to be very clear who bears the damage, who bears the cost or burden of pass-on. If it's customers, it's one story. Then you charge higher prices and your customers suffer. Maybe that's your workers because you start paying them lower wages. But there's got to be a party which actually bears the burden, and you have to identify that party. And so once you take care of overcharge effect and pass-on effects, then there is something else. There is something which economists call volume effect. And just to give an example of it, you could think of the following situation. For instance, your company experiences an increase in costs by €1, and you raise your prices also by €1. So some defendants may be tempted to say, look, you actually haven't suffered any damage. Maybe your cost went up, but you also increase your prices to exactly the same extent. So maybe there was damage to your customers, but definitely not to you, because you have essentially passed on all the cost increase. There is a fallacy in this argument. Things are not so simple, and the reason is that typically firms face a downward sloping demand. So if you raise your prices, your consumers are likely to buy less, or they're likely to buy less frequently. And therefore, you will sell fewer units. And this means that you could have earned some margin on these units, which you haven't. And that would be something that you lose. And this is what economists call volume effects of the margin lost on those units that you could have sold, but you haven't. On a conceptual level, it's important to understand that the pass-on effect and the volume effect actually go hand in hand. Essentially, they are two sides of the same coin. If you pass on something, in principle, you're likely to sell less because the price has gone up. How much? That will depend on the shape of your demand curve, and this is where you may need to do some complicated analysis or use sophisticated econometric techniques, because essentially you need to test how sensitive the demand curve is, and other things equal, you could probably say that if demand is very sensitive, then by passing on cost increase, you're going to lose a lot of volumes, and therefore the volume effect will be, in relative terms, significant. Now, if your demand is insensitive to prices, so even if you pass on your costs, maybe there will be no so much reduction in sales, and therefore volume effect will be relatively small. And this is a sort of useful theoretical benchmark to keep in mind. But of course, in practice, you will have to deal with numbers. You will have to really estimate these effects and really deal with empirical issues arising from all this. And I think in the interest of time, I'll probably stop here, but I would be very happy to take questions afterwards.
Thank you very much for your presentation, and definitely we have questions, but we are taking them in the panel discussion, which will be after this section. So be prepared to participate in the panel discussion. Thank you very much to Mr. Prozhansky from RBB Economics, Brussels. And we are moving forward. The next speaker of ours will open up the picture on causality of damages. It's my pleasure to introduce here in our digital stage Dr. Lauris Rasnačs, University of Latvia, and Rodl and partner. Mr. Rasnačs, the floor is yours.
Thank you very much, dear ladies and gentlemen. It is my pleasure to speak among such honorable company. And I hope you will find my today's topic interesting as well. And in my today's topic, I will try to cover some aspects regarding causality of damages as one of the preconditions of infringers' liability against potentially injured persons. If I may ask for the next slide, please. Yeah. And during my presentation, I will not focus on matters dealing with passing on, already mentioned by Dr. Prozhansky and also covered by several other authors. I will rather instead focus on some matters dealing with more general concepts of causality stemming from the tort law and applicable also in these claims for antitrust damages. Why I think these aspects are important? Well, of course, causality of antitrust damages is a quite complicated matter, but however, these general concepts of causality, which have been developed actually through the centuries, are quite sophisticated as well, and in general appropriate for proper attribution of liability for these damages. However, there are some aspects which I would like to emphasize. And next slide, please. And first of all, I would like to say that a couple of words about general properties of causality. One of the main role of causality is to provide a fair balance between interests of injured persons, injured parties, and also the persons which may be held liable for the particular infringement. Therefore, causality is one of the mandatory preconditions for distributing liability and providing also a fair resolution. It is important to emphasize that in a lot of cases, and I believe it is a very true aspect also in cases dealing with antitrust damages, there should be made a certain distinction between factual causes and causes which could be considered as legally relevant. And therefore, the theory of cause supervenience, or the main legal cause, and of course there could be in some cases several such mainly legal causes have been developed, which I will briefly touch also in my further presentation. Next slide, please. And it is not surprise that causality has been mentioned and has been emphasized in several judgments, also in the judgments of the European Court of Justice. And I took one of the findings from quite an early case, Manfredi, also emphasizing causality as one of the preconditions. In quite a similar wording, this importance of causality has been repeated in several more certain judgments as well. But what is a slightly surprising thing, or at least at first glance may look a bit surprising, is that apart from emphasis that causality is important, actually neither European legislator, neither case law has very much assessed and analyzed the details of causality in antitrust cases. So basically there is a statement that it is important, it is one of the mandatory preconditions, but it is a thing where basically in at least major part of cases this analysis ends. And in this context, also the Private Enforcement Directive in its 11th recital also mentions in similar sense the importance of causality. However, basically provides that national courts are entitled to assess and analyze causality according to their own law, as far as it does not create obstacles for equal and effective application of European law. But again, in my opinion, this equal and effective application, these both principles, may be quite substantially affected by different rules in different member states. Why? Because although you can find opinions in the literature that basically these causality rules in different member states are not so different, this is a statement which is quite discussable, in my opinion, and in order to give you a bit more detailed insight, I would focus on some of the main particularities of assessment of causality in some different member states and jurisdictions. Next slide, please. And the main issues which I would like to generalize in case of antitrust damages is that basically, and where I can agree, that in nearly all European jurisdictions, the analysis of causality starts with so-called conditio sine qua non, or in common law system called but-for tests. So basically, you have to find a cause without whom there would not be no damages or other infringement. But as it is quite precisely and ironically remarked by a professor Cēs van Dam, application of these tests can quite easily lead to the conclusion that the main cause for nearly every damage is the initial sin of Adam and Eve in the Garden of Eden as a cause. And needless to say that such conclusion will not help very much, neither in case dealing with antitrust damages, and neither in other cases. Therefore, it is obvious that further more sophisticated criteria is needed, and this set of more sophisticated criteria is a field where the approach of different member states are quite substantially different one from another. Next slide, please. And if I can also use the statement of Professor Ezrachi, also a bit, if I understood correctly, mentioned by Dr. Brzezinski, then private enforcement can be used as a sword and sometimes also as a shield. I think this comparison is also quite correct. But if we look to the causality rules, then we can easily conclude that there actually are different types of swords and also of shields in each member state. Next slide, please. And as with the first example, I will start with a German approach, which is considered by a lot of scholars and practitioners as a most sophisticated approach dealing with causality. And basically, in German system, you have this three-step approach. The first one is also, of course, this conditio sine qua non, but then comes a so-called adequacy theory, which has a lot of sub-series, but the main points of this theory is that it analyzes whether a particular damage is an adequate cause of particular infringement, and therefore whether it was foreseeable by potentially liable person, and also whether this consequence damages in our cases are not too distant from the cause. So it is dealing with proximity of causes. And one more aspect where I believe this theory is quite unique. It separates two types of causalities. The one is so-called haftungsbegründete Kausalität, so the causality which establishes a liability, and the second one is a so-called haftungsausführende Kausalität, causality which establishes certain amount of harm. And of course, when we are dealing with antitrust damages, both these types are important. And the third step of analysis of causality in the German system is so-called analysis of protective purpose of law, so-called Schutzzweck der Norm, where you shall analyze whether the actual damage is the one which was intended by the legislator to prevent by a particular legal provision. And one more interesting and perhaps important characteristic of a German approach is a quite high threshold of probability. So basically, in order to find something as a cause for any damage, you shall be merely certain that it is a real cause. Next slide, please. Regarding France, there are some similarities between French approach and German approach, and at the same time there are some important particularities. And one of the important particularity in the French approach, in my opinion, is that French system uses quite a lot of reputable presumptions. And this is one aspect which seems also the European legislator have borrowed from this French system. So put by taking this reputable presumption of overcharge regarding cartels also in this private enforcement directive. Another thing which may be important regarding antitrust damages is that French legal system has quite an elaborate approach dealing with situations of loss of chance. And one more aspect, if there are several causes for one group of damages, then a particular expert can help the court to assess a certain percentage from the overall amount of damages which are attributable to the certain cause and therefore to the certain respondent. Next slide, please. In a common law system, now in European Union represented only by Ireland, there are again some similarities with other jurisdictions, but the level degree of probability is quite substantially lower. So it is in some form an antithesis of German approach. which requires quite lower threshold for a possible cause in order to be established as a legally relevant one. Next slide, please. And I would like to draw your attention to some helpful, in my opinion, lessons from European jurisprudence. These cases are, as you can see, quite old, and they're not directly dealing with competition law or matters of antitrust damages, but at least in my opinion, there are some useful findings which can be helpful also for the case of antitrust damages. So the first one, the Smolder case, is that basically from the scope of potential causes, the typical risks of particular industry should be excluded. So in other words, when you're dealing with especially assessment of amount of damages, you shall exclude some losses and similar situations which actually are caused by typical risks of the industry. So here we can come also to this protective purpose of rule, that basically the purpose of antitrust rules is to prevent harm caused by violations of these rules, not to provide compensation for the other risks. And another useful aspect coming from the second case is that the party who has faced the damages shall not remain inactive, but also shall contribute properly and reasonably in order to mitigate the amount of possible damages. Another also useful provisions provided by Advocate General Kokot in this Otis case, which also gives me an impression that we can speak about relevance of adequacy and proximity dealing with antitrust damages. Next slide, please. And I'm already over my time limit. I will try to be quite short. And the things which I would like to present and ideas, not as a solution, but rather as a matter of further discussions and encouragement for these discussions, are the following ones. First of all, although for time being, causality rules are left for the member states, in my opinion, there shall be discussion about uniform causality rules and their uniform application, because the differences between member states may substantially affect the effectiveness and equivalence of antitrust provisions. And it shall not rely only regarding these passing on issues, which are quite regulated and quite covered, but it also reflects to the causality issues in general. And in the same time, I would like to come back to the initial general role of causality to provide a fair balance between all involved parties. So, of course, injured persons shall receive proper compensation for their loss, but again, the overcompensating is also something which shall be avoided. Or, as in German legal system, there is this danger of so-called Haftungslawinen, avalanche of liability emphasized. In other words, antitrust damages shall not become as a tool for market players to claim funds, which in another situation without infringement, they would not be able to achieve. Next slide, please. One more idea for discussion is that, in my opinion, these uniform rules shall cover both aspects of causality, both dealing with causality of creating liability and also causality establishing the amount of liability. And it shall rely on economic assessment, which in its turn shall assess also adequacy of possible causes, possible contributory negligence, as well as establishing these main causes or cause supervenience. And of course, the required level of probability, of course, also is something which shall be, in my opinion, decided by the legislator, because as I told, there is substantial difference between this German approach and common law approach. And last but not least, one more matter for discussion. As we know, at least the European Commission is allowed to impose symbolic fine or not fine at all in case if it is dealing with some novel infringement, and such instrument is applied in order not to discourage competition. And in my opinion, therefore, there is a place for the same reasons also to discuss how to deal with possible damages in these matters. Well, maybe there also these damages should be granted only symbolically or even not at all. And next slide, please. These very brief are my thoughts, which, as I told, I put not as a final and ready solutions, but rather as a matter of discussion, which I would like to gladly encourage. Thank you very much for your attention and hope for an interesting discussion.
Thank you very much to Drs. Lauris Rasnačs, University of Latvia, Rodel and partner. And we are moving forward with the next presentation. Is the presumption of a 10% cartel surcharge lawful? That's the question, and that's the topic of next presentation. My pleasure to introduce here in our digital stage Mr. Uģis Zeltiņš, University of Latvia, Cobalt Legal. Please, the floor is yours.
Thank you, ladies and gentlemen. It's my pleasure to appear amongst the distinguished panelists who have made such great contributions. I will be speaking about an issue that is much closer to home, namely the 10% cartel surcharge presumption that we have had on our statute books since 2016. Now, if we may start with a presentation, that would surely be helpful to follow through the rather simple message that I want to convey. Let's move onwards to the next slide and the one after that, which will zoom into the respective provision of our Competition Act. It is Article 21.3, which provides, unsurprisingly, as all European Competition Acts now should, that there is a presumption of harm where there has been a competition law infringement, a cartel infringement, but then goes on to say that it shall be presumed that as a result of that infringement, the price has been raised by 10%, unless proved otherwise. So this is a rebuttable presumption. Let's now move forward. I may also mention that there is an interesting company in which Latvia finds itself as regards the cartel surcharge presumption. A very similar provision appears on the books of Hungarian laws. In fact, Hungary introduced this sort of regime before Latvia, and I believe we used Hungarian blueprint when amending our Competition Act in 2016, when the 10% cartel surcharge first appeared in Latvian Competition Act. As you can see, the wording is not identical, but very similar indeed. Let's move forward now to the subsequent slide. And that will be, of course, as it should be, the Antitrust Damages Directive. The basic document when we speak about damages actions in antitrust cases in the EU. Let's move forward. Article 17 of the directive states that a member state must introduce a presumption that cartel infringements cause harm. And of course, the directive also instructs member states to ensure that this presumption is rebuttable. Next slide. But the really interesting thing in this regard appears in recital 47 to the directive. That recital states that, of course, it is appropriate to presume that cartel infringements result in harm, and that is exactly what Article 17 that we just saw instructs member states to presume, but then goes on to say that this presumption should not cover the concrete amount of harm. Therefore, the considerations of the EU legislator revealed in the directive go contrary to the legislative choices made in Latvia and Hungary, the two EU member states, which do have a surcharge presumption specifying the amount. Let's move forward now. And we will have to speak very briefly about the rationale of a European legislator for opting to dispense with a quantum presumption, and indeed for specifying in the preamble that the quantum presumption should not exist. The first document, let's move forward now to the next slide, will be the impact assessment for the draft directive. It's the draft which later resulted in the Antitrust Damages Directive adopted by the EU legislator. Interestingly, the Commission has considered explicitly that a quantum presumption could be introduced, but the Commission itself dismissed that idea as inappropriate. The Commission stated that this presumption risks becoming a disincentive for victims to request higher damages, higher than presumed, and also this option would not even reduce litigation costs. Those were the expectations of the Commission. Let's move forward now. So in addition to the risks of undercompensation that a presumption of this nature must entail, there is also, of course, the risk of overcompensation. And let's just bear in mind that under the Antitrust Damages Directive, member states may not introduce provisions which are liable to lead to overcompensation. That emanates from Article 3, Paragraph 3 of the Antitrust Damages Directive. We can move forward. Now, Latvian Parliament, as I said, adopted the presumption in 2016. and then voted for it once again in 2017 when the Antitrust Damages Directive was fully implemented into Latvian law. So on two occasions, in two draft bills, in two draft laws, the Parliament considered the issue. And the Parliament's legal service objected against the quantum presumption on 4 separate occasions. Let's move forward to the next slide. The first 3 occasions occurred in the context of the 2016 amendment. The first report on the bill dealing with quantum presumption from the legal service of the Parliament stated that the legal service expresses doubts about the lawfulness of specifying the quantum presumption, and stated that it is for the claimant to prove the damages. So here the legal service was clearly concerned about possible overcompensation resulting from this sort of quantum presumption. Let's move forward. The next time the legal service objected several months later, before the second reading of the bill, it's already referred to the preamble of the directive. It invoked recital 47 explicitly and proposed a wording which would dispense with the quantum presumption and would be worded in a manner similar to Article 17 of the directive. Let's move forward to the next slide. And that is a letter, again, prepared by the legal service, now also before second reading of the draft law. And it again states that there may be a lawfulness issue with a quantum presumption. And interestingly, now the legal service invokes the risk of undercompensation, adopting the concerns that the Commission had raised in its impact assessment to the draft directive. Again, the legal service proposed to dispense with the wording submitted to the parliamentarians by the Ministry of Economy. Let's move forward. And this issue came before the Parliament again in 2017, when the next installment of amendments had been prepared in order to fully implement the Antitrust Damages Directive. And again, the legal service objected, mentioning incompatibility with the directive in very express terms. Okay, let's move on. We may ask, what are the consequences of Parliament acting in this manner, seemingly in contradiction to the preamble of the directive? Of course, the first answer that comes to mind is that preamble has no binding legal force. Here's just a random but often cited EU court's case dealing with insemination of bovine animals, making just that point. Let's move on to the next slide. And it states explicitly that the preamble to a Community Act has no binding legal force and cannot be relied on as a ground for derogating from the actual provisions of the Act in question. I want to emphasize the word derogating. Now, we may ask if an interpretation of Article 17 of the Antitrust Directive, which would be somewhat restrictive, but based on recital 47 of the preamble, would be a derogation from the text. I think it is useful to have a look at some instances where the European Court of Justice has relied on recitals to interpret the provisions of directives. Let's move forward to the next slide, and we will be talking about two examples where the European courts really restricted the use of, restricted the scope of application of operative provisions in directives on the basis of what's said in the preamble. The first example deals with a directive dealing with food supplements. We can now move forward and have a look at the relevant provisions of the directive. Basically, it says that Annex 2, which lists a number of food supplements, may be modified, and the provision enabling such modification does not contain any criteria as to how, as to what modifications are permissible when the Commission, in the so-called comitology procedure, engages in modifications. Let's move forward. The issue of validity of the directive came before European Court of Justice, and it referred to legislators' considerations contained in the preamble of the directive and stated that those considerations limit what the Commission can or cannot do when it modifies Annex 2. Specifically, the court stated that the words used in the preamble limit the Commission's power to modify the lists. The preamble shows that in this instance, the community legislature had laid down the essential criteria to be applied in the matter when the powers thus delegated are exercised. We can now move forward and bear in mind that here the preamble was used explicitly to limit black letter text in the operative part of the directive. Okay, second example. Let's move to the next slide and see what the directive is about. It concerned genetically modified organisms. Next slide, please. And the thing to notice about the directive is that according to the preamble, the directive should not cover certain genetical modification techniques which have over a long period of time proved their safety. This idea is implemented in Article 3.1 and Annex 1b, which says that specifically mutagenesis is a technique which shall not be regulated by this directive, without referencing the idea of long-lasting experience and general impression of safety of this technique. Now, let's move forward and see what the European Commission, what the European Court, has to tell about the interpretation of this directive. The EU Court very explicitly invoked recital 17 of the preamble that we just read, the recital dealing with the idea that certain safe techniques which have accrued lots of experience should not be covered by the rules required by the directive. And then went on to say that this consideration contained in the preamble restricts the discretion afforded to member states when they exempt genetic modification techniques from the scope of directives rules. The Court of Justice stated that despite rather clear black-letter text in the operative provisions, not all mutagenesis techniques can be excluded. If the techniques are new, if the experience has not, as to safety, has not yet been accrued, the safeguards required by the directive must apply. Let's move forward. And let's speak shortly about whether rebuttable presumptions matter. If a rebuttable presumption were contested before the ECJ or before a constitutional court, the obvious arguments, of course, would be raised, and that would be that as long as the presumption is rebuttable, everybody is free to do so, and therefore no real harm to any party can arise. But let's look at what the European Court of Human Rights has stated about rebuttable presumptions. It has stated that Article 6, which deals with fair trial rights, is concerned with even rebuttable presumptions, not just irrebuttable presumptions. It does not regard such presumptions with indifference. And the court went on to explain that the existence of a rebuttable presumption must be weighed against the legitimate interest that this presumption pursues. Therefore, the existence of a rebuttable presumption certainly can be tested before courts. Let's move forward. A short note to make, of course, is the well-known issue of acte claire. On the basis of the acte claire doctrine, as established by the Silfi judgment, we can ask ourselves, what should a national court think about the compatibility of our surcharge presumption with the directive? Well, Silfi judgment says that a national court can make up its own mind and not ask for a preliminary ruling from the ECJ. First of all, if the answer is so obvious as to leave no scope for any reasonable doubt. And secondly, if the national court is convinced that all other member states' courts and the European Court of Justice would be of the same opinion. Now, criteria number one, I think, in our case, is not fulfilled. The doubts expressed by the Parliament's legal service, also the doubts emanating from case law dealing with the impact of preamble on interpretation, and from Court of Human Rights case law dealing with the issue of lawfulness of presumptions, clearly does leave room for at least reasonable doubt about the lawfulness of our 10% surcharge presumption. Would the answer, whatever that would be, a national court would arrive at when interpreting the directive be equally obvious to other member states? Again, in my view, not necessarily. The fact that only 2 member states have opted for this sort of presumption, I think, is indicative that the prevailing scholarly and practitioners' view in EU member states is not necessarily in favor of compatibility of such presumptions with the directive. And thus we can move onwards to the final slide with 3 conclusions. And they are, first of all, that quite probably recital 47 of the directive does limit member states' discretion when it introduces presumptions as to the harm caused by cartel infringements. Secondly, the lawfulness of our 10% surcharge presumption certainly can be regarded as act clear. And this leads to the third conclusion, which is that if a national court were to encounter a case where the existence of that provision is decisive for the outcome of the case, it would be bound to refer a preliminary question to the ECJ. So in the future, I don't know whether it's in the near future or if it's or if we can expect this in the more distant future, but we can look forward to, in my view, a very interesting case on the compatibility of our presumption with the directive and possibly Charter's rules on fair trial rights. Thank you.
Mr. Uģis Zeltiņš, University of Latvia and Cobalt Legal, and thank you indeed also for the visualization of documents. Very pleasant way to follow the thought through the documents in a digital way. Thank you very much, and see you in short time in the panel discussion. Our final speaker here in this section, Matīs Dzelve, Competition Council of Latvia, with a topic, Competition Council's topical matters in actions for damages. Mr. Dzelve, the floor is yours.
Thank you so much. Let me just say that it's an honor of being here, and thank you for inviting me. I'm Matīs Dzelve. I'm a legal advisor at the Competition Council of Latvia, and today I'm going to take you through the Competition Council's topical matters in actions for damages. So in the next slide, we have a table of contents. So we're going to start with some very brief background information, and then we'll continue with aspects in regards to how the Latvian Competition Authority has been fostering and, in a sense, contributing to the actions for damages and successful reimbursement after competition infringements. So in the next slide, we have so the background. So what's the role of the Competition Council in damages claims? Well, in a typical case, the CC does not take up the role of either the plaintiff or the defendant. In fact, it mainly has more of a supporting role where it can be asked to provide opinions by the court or can do so on its own initiative. And whereas the other significant involvement aspect can be the request for disclosure of evidence from the CC's file. Still, in addition to all that, we do indirectly assist in other ways. So in the next slide, so methodology. One of the most recent and topical involvement points of the CC is the methodology for quantifying damages and pursuing them when it comes to violations of competition law, or methodology for short. So what is it exactly, and what does it hold? Well, the idea with this was never to invent a wheel all over again. Instead, the idea was to look at what sort of information is available out there, to look at what kind of guidance has the European Commission offered, to look at what the European Court of Justice has said, to look at what the national courts are saying, and also especially what the Supreme Court has stated, and then to look at what the other helpful resources out there are for pursuing damages after competition infringement. And then essentially to kind of fuse it all together and create this single up-to-date national level document that would compile useful information for all stakeholders. I mean, while this was more or less specifically created with public entities and their undertakings in mind, we are hopeful that this can also be helpful to private undertakings, lawyers, judges, and basically anyone else who's in a market for learning more about the interplay of actions for damages and competition infringements. To that end, we at the CC are open to keeping this document as up-to-date as possible. And if you ever have any comments as to how we could further improve it, we're all ears and we'd love to hear it. So in the next slide, now, why was it created? Granted, as mentioned, it's for anyone to have a better grasp of how actions for damages work with competition infringements. However, there were actually some deeper and more profound reasons why. So first, it is part of a much bigger compounded effort to make actions for damages mainstream. And this was stemmed by the Cabinet's Order number 49 of February 2020, which stated that the CC has to create a methodology of this kind. Now, the second reason, the CC also had a very vested interest in this itself. To go a bit further on that, that's kind of the idea mentioned by the European Court of Justice in judgments like Courage, Fledder, and Otis and others, among many other judgments. It's this idea that actions for damages make a significant contribution to the maintenance of effective competition by discouraging collusion. Because undertakings who infringe competition law will not only have to face the fines that can be imposed by the national competition authorities and also the European Commission, but also because they will have to reimburse damages that they have caused. In other words, it plays kind of a deterring role. And the Competition Council did want to contribute to that, especially considering the third why, which is that public undertakings crippled by bid rigging very rarely pursue the damages that they have suffered due to the infringement. In fact, to give some statistics, despite the CC having uncovered 13 bid rigging cartels between 2015 and 2020 and having fined 65 undertakings total, no action has been taken by these public entities so far. And if you look at the year 2021, then the picture isn't any brighter there either. And it's a huge problem because that's taxpayers' money that doesn't get to go where it is supposed to go, but instead it gets to stay with the infringers. Now, in the next slide, so as for the methodology and its structure, it attacks the actions for damages from two sides, namely with two large chapters. First chapter is the pursuit of damages. It kind of generally covers the interplay of Latvian civil procedure law, competition law, and damages directive, as well as it aims at promoting the general understanding of the matter. And then we have the second chapter, which is quantification of damages, which works purely as a roadmap, meaning it basically briefly explains what the most prominent methods for calculating damages are and how they essentially work. And then it offers a list of other resources to learn further from. The methodology can be found on Competition Council's website. And again, at the CC, we do encourage any comments that you might have in making this the ultimate resource. Now, in the next slide, coming back to the opinions that the Competition Council can offer either on its own initiative or by the initiative of the court, the CC doesn't have the power to offer opinions on absolutely anything competition law related. Meaning there is often this impression that Competition Council can quantify damages for you after an infringement, but that's wrong for at least two reasons, the way I see it. First, the competition law allows for opinions by the CC regarding the application of Article 101 or 102 of the Treaty of the Functioning of the European Union only. And second, the CC doesn't have to calculate the exact damages that have emerged for the victims of competition infringement when proving a case. What the CC has to prove is that collusion or market disruption has happened, and that's not the same as calculating damages, which just means that it's not the kind of evidence that the CC will typically gather when it comes to requests for information or during inspections or by any means otherwise. And even if the CC offers opinions, these are not decision-like ones. Instead, they are rather a matter of offering guidance for the court and for the court then to arrive at the judgment. And yes, we do encourage that any opinions are asked through the court in any given relevant case. Now, in the next slide, what about some other ways of encouraging that damages are paid by the infringer? Well, there are two kind of tools in the Competition Council's tool belt to further facilitate the reimbursement. The first has to do with the Cabinet Regulation number 179, which lays out the rules on calculating a fine for an infringement. This regulation states that if an infringer is to offer and repay any damages that it has caused, it can be viewed as a fine mitigating factor, which, however, is a rather rare occurrence, to say the least. I mean, as far as me and my colleagues at the Competition Authority are aware, there haven't been any cases of applying this mitigating factor in the last 5 to 10 years at least. Still, as a facilitating tool, it does exist, and we are hopeful that in the future it may be applied more. As for that other tool, it has to do with proving one's reliability or restoration of credibility to the contracting authority, meaning whenever an infringer has been taking part in a bid rigging cartel, in addition to the fine, it will also receive a prohibition to participate in public tenders for 1 year, unless it was a leniency applicant. And so, whereas reimbursement damages that it has caused is one of the steps in removal this prohibition early. Now, on that note, starting next year, the prohibition will no longer be just 1 year. Instead, it will now be 3 years, which has the hope of further promoting the discouraging effect of taking part in a bid rigging cartel. Now, we can move to my last slide. We come to the centralized actions for damages. So with the already mentioned Cabinet's Order number 49 of February 2, 2020, the CC was also given a task to explore the possibility of centralizing damages claims when it comes to public funds, meaning when public funds are at play. Since the work is still an ongoing one, there's not much that we at the CC can comment at this time. I mean, the possibility has been explored with several institutions, but the final outcome is still pending. So while I did want to bring your attention to this aspect, I'm afraid for now I have to leave it at just that. And so, yes, we can go to my last slide. Thank you very much for your attention, and yeah, looking forward to the discussions in the panel.
Thank you very much to Mr. Zelva, Competition Council of Latvia. Strictly confidential, that was the slide on the moment, but now we are switching over to our panel discussion. Couple of remarks because of how we would say this relativity of time. That was the conclusion I wanted to find, that the time is relative, and now we have to press our panel discussion in a bit shorter time period. We're going to do 10-15 minutes of panel discussion. Then we're going to skip the break and switch to the next session. So the next session participants, please be ready to jump in according to timetable. We're gonna get some time out of the lacking the break here in the studio. Okay, but if we are speaking on the panel discussion, then participants in the panel discussion are all of those which are participating in a section 2, Professor Haukap, Honorable Judge Madam Reine, Vitaly Pruzhansky, Dr. Lauris Rasnač, Uģis Zeltiņš, and Matīs Dzelve. So we will start our panel discussion in a very short moment. We're going to see each other on the screens. And while, yes, and now we are seeing each other on the screens. And we have a couple of questions, in fact, considering the bigger picture, in fact. Professor Haukap at the beginning was mentioning that it is important to stimulate incentives to detect cartels. And that there is a difference how those incentives are being played out in the United States of America and Europe. Then the question is how we could stimulate even more those incentives to detect cartels. What are the possible instruments that could be used? I would ask this question to Professor Haukap, and then others who want can jump in with their additions if there are some. So Professor, the floor is yours. How to stimulate incentives to detect cartels more early?
Well, at the moment, I think there are two issues that come to mind and that are being discussed. One is that I think we haven't found a perfect way yet to how to interlink private damage claims and leniency applications. At least there is some argument and some experimental evidence also that private damage claims may make it less likely that firms apply for leniency because you cannot exempt them from the private damage claims, actually. And I think at the moment there's only imperfect ways, actually, to get out of this situation. In Germany, at least, Andreas Mund has started a discussion, the president of the cartel authority, whether we shouldn't exempt the leniency applicants also from the private damages. I'm not a lawyer, so I understand it's legally a complicated issue, but from an economic perspective, it appears to be quite sensible, I must say. The second issue that has now arisen, at least in Germany, is that the court proceedings regarding damages are really, really lengthy, which seems that firms are getting more and more discouraged, actually, to file for damages because it ties a lot of management resources and other resources of the claimant. So there's currently a discussion also involving how can we somehow what should be the level of proof that is required in private damage claims in order to facilitate a more rapid court decision making, actually. And I think these are 2 points that are worth investigating further for the future.
Thank you very much, Professor. Are there some additional comments on this question and answer from participants' side in the panel discussion? If no, then we are moving forward. There was also, I had the note from one of the panel speakers, Dr. Lauris Rasnač, already gave a note that he has 2 questions, in fact, to other panel speakers. So, Lauris, the floor is yours.
Thank you very much. My first question would be to Professor Haukap. You mentioned that Professor Haukap these issues about information asymmetry and situations, which I can easily imagine, that there may be insufficient data for experts to provide their opinion. What is your opinion? Would some sort of preliminary provisions about providing of evidence is mandatory for both parties. Something like this production of evidence in common law system would be helpful in this respect. Thank you.
Yes, indeed. I think we need to make improvements here, and of course, the incentives to produce this information are quite different, actually. So often, not always, but often, the defendants, which are the cartelists, have access to better information, but they have little incentive to produce this information. And from outside, you don't know exactly what kind of information they have. Yeah, you have some sort of idea, but sometimes they have changed their IT system, or the data has been outsourced to third countries in Asia or somewhere. And so my personal experience is, if they benefit from producing the data, they make a lot of effort to produce that data. And if they don't think it's valuable to them, they don't really make any effort to produce this type of data. So that's why even though I now understand that sort of the 10% or 15% presumption may be difficult for legal reasons, I would say from an economic perspective, it could have the benefit that it increases the incentives for defendants to produce information. Actually, because it sort of shifts the burden of proof a little bit, at least towards them. And from the economic principle that the party that is the sort of least cost information provider should provide that information, I think it makes some sense.
Thank you. And as I understood, there is a second question from Dr. Rasnic too.
Yeah, thank you very much, Professor Eochaidh. My second question will be to colleague Uģis Zeltiņš. Thank you very much for your interesting presentation and opinion. But one question from my side. You provided certain concerns about this irrefutable presumption of amount of damages. What would be your suggestion instead of this presumption, also taking account these aspects regarding disproportion of information, this information asymmetry, and also the absence of incentives for instance, for cartelists, which usually have way more information about all the details than the potential plaintiffs. Thank you.
Thank you, Lauris, for the question. Let me state at the outset that I don't know if our quantum presumption is incompatible with the directive. It may be or it may not be. What I am sure of is that if I were a judge, I would refer the issue to ECJ, because everything I know about how the ECJ deals with interpretation by taking into account what the preambles say leads me to have at least prima facie questions about the lawfulness. Could go either way. I mean, the orthodox solution would be to opt for what almost all EU member states except Latvia and Hungary have opted for, and that is the text of the directive. There is a presumption of harm, but there is no quantum presumption. What could be done, especially in Latvia, given our paucity of antitrust private enforcement cases, I think is first and primarily discovery of evidence. The courts need to take a more proactive and a more thoughtful approach to how disclosure of evidence is ordered, and to how the parties are instructed to deal with large volumes of data. I think those two issues are not being given enough thought. If they were addressed, I think many of the issues that we are concerned about could be resolved without even resorting to the quantum presumption. Thanks.
Thank you very much. And we are saying also goodbye to Mr. Vitaly Prozhansky. He has to go to the airport. Thank you very much for his participation. The next question goes to Madam Honorable Judge, Madam Reine. You heard in this panel session, in fact, different perspectives on the matter. The question is, from your perspective, from bigger frame, are there challenges in having different perspectives in the matter? Are there some challenges of perspectives in the field, or everyone are basically on the same page and development is just a question of time? Maybe a general comment on that.
Thank you. I'm not sure I fully understand the question, but the issue is very complex. As I have tried to show a 360-degree perspective of the situation, anything that is related to competition law is an intertwined, there are multiple intertwined elements involved. First, there is a debate between an administrative authority and a company involved about whether the practices comply with the antitrust regulation, with the competition law. That is a two-way street, because this is not a question of a decision itself, but this is a question of a reverse action for the error committed by the administrative authority. And then it adds on an additional layer of discussion of third parties claiming damages from the violation itself. And adding another layer, that the perspective of the timeline that is being involved because of the complexity of the issue, the complexity of economic calculation, the complexity of legal evaluation. And then you also add an additional layer to that, a complexity then at the final stage of the timescale, of the time bar, because the claim for damages may be brought only after one establishes the violation of the competition rule. That means that this is the closing period, the closing stage of that discussion, which comes in years and years and years after the beginning. So there is an affecting question of the time bar for claims and of access to evidence. And if we add again a complexity to that, another layer of the cross-border element, because we have internal market, and it is a very rare situation within the European Union that the situation is purely internal. And even if we know from the case law, even if the situation is purely internal, it can still lead to the application of the European Union law. Then you have basically a universe in itself. And as I have mentioned, we have had the beginning of the jurisprudence concerning the deadlines for submitting the claims, where we said that 3 years timeline is too short, but there hasn't yet been jurisprudence saying, for example, that whether such timelines, the deadlines as 10 years are fine from the perspective of legal certainty, or there are better ways of achieving it. We have not yet have a discussion on the suspension periods and restitution periods, and then we have not yet had a discussion on the effective access to evidence for the private enforcement claims. So I think there is still a long way to go.
A long way to go.
And a big debate ahead of us.
Thank you. Thank you very much. The final question in our panel discussion here goes to Mr. Zelva. Do you, taking into account the complexity of the picture and also the challenges which are coming, linking everything together, do you feel some lack of resources in the broadest perspective, lack of data, lack of human resources, lack of expertise on the national level for the Competition Council of Latvia? That question was addressed in Latvian, so the national issue addressed to national expert, please.
Thank you. From a pure, did I get the question correctly? It was more about the total look at what the problems
total
are,
look,
right?
yes, total look.
Not just Competition Council. So, well, the way I see it, one of the obvious things that already my colleagues at the panel touched upon is the lack of the reference scenario and to compare it with the real scenario to quantify the damages properly. And so, to some extent, it would be great if Competition Council with the during inspections to also gather evidence that would later contribute to helping parties raise those damages claims and successfully getting reimbursement. But there are a lot of legal issues that arise with that, because then we have the Competition Council then basically works as a private entity that can later ask for damages, and it kind of defeats its neutral stance and objective look at all the the matter when investigating competition infringement. So that's definitely a no-go. But as for any other solutions, I like what the Justus Haukup mentioned, that the rebuttable presumption, it basically forces the defendant to provide the evidence, say the prices that it used during a certain period, and so the quantification, yes, it may ultimately rebut that it's not 10%, but then the courts at least have some tools, have some threads to grasp on and assess what the actual damages could be. So yeah, I think the issue is a really complex one, but
okay, thank you. Complex issues, complex answers. Thank you very much at this particular moment to all our panel discussion participants and participants of second section of this day. Thank you very much for your time. At the same time, we are continuing and moving forward to the next section, recent developments in competition law and policy, and as a red thread which is going all the events through is the message from Honorable Judge Inga Reine, General Court of the European Union, recent developments in energy law. So, Madam Reine, the floor is yours again, please.
Thank you. I will be more focused with my second presentation than with my. Will not attempt to give you a 360 degrees about the energy law, but focus maybe on three main subjects, and this is the evolution of the understanding of the energy market, the very specific issue related to the dispute settlement mechanism, and then I will give you a couple of spoilers for cases that are currently pending before our court, which raise a couple of very interesting issues indeed, I believe. Next slide, please. So a brief recollection of the legal provisions. We have a number of provisions in the treaties of the European Union that are governing various policies related to energy market. And then we have the overlaying treaty, the Energy Charter Treaty, which provides additional elements and the dispute settlement mechanism. And not only EU member states are parties to that treaty, but also non-EU member states as the major energy suppliers to the European Union. And this is a very important document without which the understanding of the European energy market and European energy law would not be possible. But the red thread, the transversal thread through this discussion is, as we know, energy issues are still issues largely related to shared competence between the European Union and member states. Next slide, please. So what has been the major development in understanding the energy market of the European Union is, of course, the recent judgment. It's last year judgment in Nord Stream case. This is the Opal pipeline case. And why was it important? Because it was the decision of the European Commission authorizing the use of the line in Germany, which Poland contested. And that was an important element in the debate where the European, the Court of Justice recognized the fact that the energy market is based on the principle of energy solidarity, that does not only create a legal relationship between a single member state and the European Commission, but it also creates rights and obligations of member states vis-a-vis other member states. So these issues should not be regarded in a narrow sense of the term, but it should be regarded as an issue of the common European market, even if it's a single member state involved. This is indeed a very important development in the jurisprudence, and I will maybe show you another case where this conclusion becomes pertinent. This is a pending case. Next slide, please. But then the hot potato right now related to the energy law. This is, of course, the dispute settlement mechanism and the current revision of the Energy Charter Treaty, which produces quite some hot debates between European Union member states and non-European Union member states. And this is one of the issues that I would like to address today. As you know, Article 26 of the Energy Charter Treaty provides for the dispute settlement mechanism, and the major element of that these are the arbitral tribunals. This brings me to the following point. Next slide, please. You may remember of the famous case, Achmea, which we all know very well. It has nothing to do with energy law as such, but this is an important judgment that opened a whole debate about relationship and applicability of the European law by ISDS mechanisms, the arbitration tribunal. And if you remember, in Achmea judgment, the Court of Justice raised a red flag with respect to arbitral tribunals for the bilateral investment treaties between EU member states, for the reasons that arbitral tribunals may interfere with the autonomy of EU law by the fact that they're outside the judicial system of member states, and therefore they are not able to ask questions to the Court of Justice of the European Union. But Achmea judgment is related to a case, a pure bilateral investment dispute between two European Union member states. That jurisprudence has received an important follow-up in the recent year. And the first one that I would like to mention is the case of Republic of Moldova versus Comstroy. And the importance of that case is that it, first of all, relates to the Energy Charter Treaty. Second, it relates to a dispute settlement mechanism. But third, what is important, that the dispute itself concerns two parties that are not subjects to the European Union law. The only connection to the European Union law of that case is that the dispute was brought between the arbitral tribunal located on the European Union territory. And in that particular case, the Court of Justice said two things. First of all, that again, that the investor-state dispute provided by the Energy Charter is not applicable to the intra-EU disputes. And again, this conclusion was expressed in the context, as I have just mentioned, in the context of the case where the only relation to the European law was the fact that the arbitral tribunal was the arbitral tribunal established on the territory of the European Union. And the second conclusion was the definition of the scope of claim and the jurisdiction, possible jurisdiction of the arbitral tribunal. And there the Court of Justice itself interpreted the Energy Charter Treaty. This is very widely debated judgment in the academic world, and this is still an important judgment to follow up in terms of jurisprudence. Next slide. What was an important development further to this debate was Miķelis judgment, and this is a judgment of the beginning of this year, which again concerns arbitration award. The arbitration award itself, again, has nothing to do maybe with the energy law, but since we're speaking about the dispute settlement mechanism, that's what makes it relevant for the discussion about the energy union. And Miķelis judgment was interesting for the following points. The dispute itself predates accession of Romania to the European Union. The arbitrary award was granted by a tribunal, arbitral tribunal located in the European Union territory. And what happened? Romania was ordered to pay. But the decision of the arbitral tribunal was delivered in 2013. That is after the accession of Romania to the European Union. And that award was qualified by the European Commission as state aid, which is contrary to the European law. What happened is that the Court of Justice believed that the Commission lacked competence to adopt this decision, since the facts of the case predated Romania's accession to the European Union. However, and I ask to move to the next slide, the Court of Justice disagreed with the conclusion of the General Court on that specific point by saying that the jurisdiction to adjudicate on that matter arises not from the facts of the case, but for the Commission to adopt a decision, but from the moment the arbitral tribunal made its award, meaning in 2013, and henceforth the Commission did have jurisdiction to adopt the contested decision. The Court of Justice did not go any further in analyzing whether this indeed constitutes state aid and whether this state aid is compatible with the treaties. This is something that the General Court will have to review now once again, following the fact that the Commission does have jurisdiction to adopt this decision. But this again is fundamentally important judgment that is in the pipeline, because it will then connect the dispute not only about the legality of arbitral tribunals, located on the territory of the European Union, but also execution of arbitral awards. And of course, this conclusion will have importance for the application and interpretation of the Energy Charter Treaty. Next slide, please. To add to the complexity of the case, Article 26 of the Energy Charter Treaty, which provides for the dispute settlement mechanism, itself has been challenged before the Court of Justice of the European Union. Belgian government has requested an opinion from the Court of Justice, and of course that opinion will have, most probably, direct implications on the ongoing negotiations on the revision of the treaty. Next slide, please. Now, a couple of spoilers. This first case that I would like to mention, the pending case, has, in my humble view, some relevance to the case, to the jurisprudence of Opal Pipeline, and to the view of, well, more limited or broader view of the European energy market, because this case concerns two mergers, and the decision was contested by one of the competitors, bringing forward two arguments, in fact, that first of all, the Commission should not have looked at the mergers in a narrow way. First of all, the Commission should not have looked at those two mergers separately, but looked at them cumulatively as part of one single merger, even if they were two steps acquiring one companies, and these are electricity companies that are involved. And given the fact how big players these companies are, we're speaking about E.ON and RWV, the RV of Germany, given the chunk of the market held by those companies and the effect produced by those mergers, the applicant claims that this effect is being felt outside the borders of Germany. And this is again where the parallel with Opal Pipeline is, that this merger should be seen from the perspective of the entire European energy market and not just a single market affecting only one member state. So this is an interesting judgment which is in the pipeline. This is a rather new case. You see it dates to the end of 2020. Next slide, please. And the final case that I would like to bring to your attention is the case of Netherlands versus the European Commission. It's again another pending case, which will still have to be adjudicated, but the essence is directly related to energy market. And this is a state aid case. In this particular case, the essence of the dispute is the decision by the Dutch government to close one of its, if I'm not mistaken, nuclear power plants. This is a big power plant located in the Netherlands. And since this is a novel issue and the novel measures introduced by the Dutch government decided to communicate those measures to the European Commission. And there comes the most interesting part of the case. The European Commission avoided pronouncing itself on the matter whether the measure constitutes state aid. What the Commission did, the Commission said that whatever is the measure is fine from the perspective of the European Union law. And the Dutch government contested that decision based on the fact, and this is the essence of the dispute, whether the Commission can claim that something is compatible with the European Union law without establishing its competence to do so. In other words, how the Commission can say that measures are compatible if the Commission is not sure whether the measure constitutes state aid. And this decision in itself, whether the measure does or does not constitute state aid, as we know from the perspective of the European Union law, may produce rights and obligations to third parties. And that is something that the judgment will have to address. Of course, I cannot tell you how that will be addressed, but I think this is an important case, again, an important spoiler for you to follow up on, because that would be something that would be applicable and that would be debated for the years to come. I will stop here. This would be a shorter presentation on my side. Maybe next slide as the final slide as a conclusion. We see that energy law is not only the law that in itself touches upon competition, it touches upon very sensitive issues of state aid. And given the fundamental role, central role of Energy Charter Treaty, it brings also the complexity of the dispute settlement mechanism, which at the time of the treaty, of the first treaty, was involved, if I may recall, for the reason of the rapid response to those disputes, because we know that dispute settlement mechanism before regular courts take longer time as compared to dispute settlement mechanism provided by the arbitral tribunals. But the newest development in the European Union law bring new challenges to the competence of the tribunal and to the awards granted by those tribunals, how these measures are being seen from the perspective of the autonomy of the European Union law, and also from the perspective of the rules governing state aid. So that's all on my part. Thank you. And now I have saved you some time maybe for further discussion.
Thank you. Thank you very much, Honorable Judge Madam Reine, and thank you very much for giving the bigger picture and wonderful case studies, in fact. Thank you indeed. We are going further. The next speaker will speak on recent cases on abuse of dominant position. Milan Christoph, Court of Justice of the European Union. Christoph, the floor is yours.
Thank you. It's a pleasure to, well, be here. I would prefer to be in Riga, but maybe next year. But anyway, so I'm very happy to be able to talk to you in this conference. I have chosen two very interesting cases to talk about state aid, abuse of dominant position cases. And basically, I've been working at the Court of Justice as a referent there since 2006. Before I worked in DG Comp in the Commission and in private practice. And now I have the pleasure of working for Laila Medina, the Latvian Advocate General. So next slide, please. I will talk to you about two very interesting cases. So that's Google Shopping and then Intel. I will have to be obviously very careful what I say because these cases are pending now before the Court of Justice where I work. But I was very careful to only choose everything that is public, and I'm sure you will find them very interesting. Next slide, please. So the first case I will talk about is Google Shopping. So you may know this is one of the three big commission decisions against Google for abuse of dominant position. This was the first decision from 2017, and then Google appealed it, and we have the General Court judgment from November 2021. And as the name suggests, Google Shopping, it's about comparison shopping services and about general search, of course. Google is known primarily for its search service. The Commission imposed a fine of 2.42 billion euros on Google because of the alleged abuse of dominant position. And that's in the market for online search, so the general search in 13 countries of the EEA. And the Commission is saying that Google abused its dominant position by favoring its own shopping service, comparison shopping service, which is a specialized kind of search, because you have the general search, you know, the famous Google search, And then you have specialized searches like the comparison shopping services. So Commission says primarily Google has favored its own service, and it has been relegating its competitors. So the Commission says that the results of product searches made using Google's general search are positioned and displayed in more eye-catching manner when the results came from Google's own comparison shopping service than when they come from competing shopping services. And also the Commission says that the latter results, which appeared as simple generic results in form of blue links, are accordingly, unlike results from its own comparison shopping service, they are demoted by Google's algorithms. So what is important in the case, as you see on the slide, is that Google had, according to the decision, Google had persistently very high market share, over 90% in all the markets, and there was an infrequency of multi-homing brand effects, and there were very high barriers to entry in this case. So what is important also, as you see on the slide, is that for the Commission decision, they decided that the market for general search is distinct, it has a distinct demand and supply compared to the content sites, social networks, and specialized sites, and that it's national in scope. Next slide, please. So the abuse, as I said, was that according to the Commission decision, Google has favored its own comparison shopping service, that's CSS, over its competitors. The Commission says that this is manifesting itself in two different ways. So the Commission says there is a demotion of rival comparison shopping services in Google's general search results, and according to the Commission, Google systematically gave prominent placement to its own comparison shopping service, so it was displayed at or near the top of general search results. So the Commission says that it questions the fact that Google did not subject its own comparison shopping service to the same treatment as its rivals. Next slide, please. So now we come to the judgment. So the judgment of the General Court, it's mostly upholds the decision of the Commission, as we will see later. So especially the General Court recognizes that the nature of the practice is anti-competitive. So the General Court says that the dominant position alone is not a ground of criticism, even if, let's say, a company like Google wants to expand in a neighboring market. But the General Court says because it was favoring its own comparison shopping service on its general results pages through this more favorable display and positioning, and at the same time relegating results from competing comparison services in those pages by means of ranking algorithms, according to the General Court, Google has departed from competition on merits. Next slide, please. So there are three specific circumstances. The first one is the importance of traffic generated by Google's general search engine for these specific specialized search, so for comparison shopping services. So the traffic that Google generates in its general search is very important. Then the next circumstance that is important is that the behavior of users, typically they tend to concentrate on first few results. So according to the Commission investigation, if the competitors of Google in comparison shopping services, if the links and the results were, let's say, later on, even at the second or third page, the Commission found in its investigation that usual users didn't even look at those results. And then finally, there was a large proportion of diverted traffic of comparison shopping services, and the fact that it cannot effectively be replaced. So the practice, according to the Commission, is liable to lead to a weakening of the competition on the market. Next slide, please. What is interesting in the General Court's judgment, so there was a big discussion, as we will see now, Google was arguing that this was a refusal to supply kind of situation where the case law is quite strict. And in the General Court judgment, the General Court found that Google was akin to an essential facility. So it said that the general search that Google owns is an infrastructure. And so the General Court says this case is relating to conditions of supply by Google of its general search service by means of access to general results pages for competing comparison shopping services. And so the General Court says the general results page has characteristics which are akin to those of an essential facility, as there is currently no actual or potential substitute that would enable someone to replace, let's say, Google's general search in an economically viable manner on the market. Next slide, please. So that is interesting. The General Court says that this case does involve access, but that it's not, strictly speaking, a refusal to supply case. So the General Court says, not every practice relating to access to such a facility necessarily means it must be analyzed under this refusal to supply case law. So that's the famous judgment Oscar Bronner from the ECJ, and on which Google has relied in its argument. So the General Court disagrees with Google and says that this case law does not apply. And then the General Court says the practice in the case is based not on a refusal to supply, but on a difference in treatment by Google for the sole benefit of its own service, its own comparison shopping service. And according to the General Court, the Oscar Bronner refusal to supply case law is not applicable. Next slide, please. So the General Court says you have to distinguish from other infrastructures. In this case, the value of which depends on the ability to protect exclusive use. And the General Court also says that the rationale of a search engine is to be open to third-party results. So according to the General Court, there was a certain form of abnormality when Google was favoring its own results. And the General Court also finds in the judgment that Google differentiated treatment, this differentiated treatment by Google is based on the origin of the results, that is, whether they come from its own comparison shopping service or from competitors. So according to the General Court, Google favors its own comparison shopping service over competing services rather than providing a better result over another result. So next slide, please. Then the next part of my presentation on this judgment is about the effects analysis, because that was also something that was strongly debated in the case. The General Court is rejecting the arguments of Google, when Google was challenging the decision concerning the consequences of the practice for traffic. So the General Court finds that the Google arguments take account only of the impact of the display of results from its own comparison shopping service without taking account of the impact of the poor placement of results in the generic results. And the General Court says what is important is the Commission had called into question the combined effects of those two aspects. So not just one, but also the other one. Next slide, please. So what is important for us is that the General Court is rejecting Google's arguments, and where Google was saying that the competition on the market for comparison shopping services was strong because of merchant platforms. So merchant platforms, so the most probably known example will be Amazon. And the General Court has confirmed the Commission's assessment that such platforms are not on the same market. What is also interesting is that the General Court annulled the Commission on one point, because the General Court found that the Commission did not establish that Google's conduct had even potential anti-competitive effects on the market for general search. And so the General Court has annulled the Commission decision on this aspect. Next slide, please. But as we will see, the General Court decided that this should not have an impact on the fine. So the General Court has analyzed the infringement and the fine calculation anew, and General Court is rejecting the arguments that the fine. So first of all, the argument that Google was presenting was that there should be no fine, because Google was saying this is a new type of conduct, for the first time penalized by the Commission. So also what happened is that earlier in the procedure, the Commission indicated that maybe it would not require Google to make modifications, or that they could maybe resolve the case simply by commitment without any fine. But the General Court disagrees and says that that does not prevent the Commission from imposing a fine eventually. The General Court also says that the partial annulment of the infringement should not be reflected in the fine, in the changes to the fine. So it says the fine must stay the same, because the Commission did not take the value of sales on the general search market into consideration in order to determine the basic amount of the fine. So it stresses also the serious nature of the infringement, and that it was adopted intentionally and not negligently. The next slide, please. Well, just very briefly, now, as I said, this case is pending before the ECJ, and this is all public information, the summary of the pleas of Google. So the Google is contesting this judgment. Next slide, please. I would like to continue now to the next case. The next slide, please, to Intel. So this is the second case I wanted to talk to you about, which is also abuse of dominant position. It's also very recent, because it's from the judgment is from January of this year. And basically, the Commission has imposed a fine of approximately 1 billion euros on Intel for an abuse of dominant position in 2009. And then, as we will see in my presentation, this case was then appealed to the General Court. Then it was appealed to the ECJ. The ECJ sent the case back to the General Court, and now we have a second judgment of the General Court. Basically, what is the case about? So the Commission fined Intel, because Intel is a manufacturer of chips for inter alia computers and phones and so on. And so the Commission said that Intel has abused its dominant position on the worldwide market for a specific type of processors by implementing a strategy to exclude competitors from the market. So the Commission says that the abuse had there were two types of conduct. One was conditional rebates, and one was naked restrictions. So the conditional rebates, the Commission said that Intel has granted 4 strategic OEMs. OEMs are original equipment manufacturers. So that's Dell, Lenovo, Hewlett-Packard, and NEC. And the Commission says that Intel gave them rebates which were conditional on those OEMs. So original equipment manufacturers purchasing all or almost all of their processing units from Intel. And also the Commission said that Intel has awarded payments to a European retailer of microelectronic devices, which is Media Saturn Holding. So, for example, the MediaMarkt shops, which were conditional on this retailer selling exclusively computers containing Intel's chips. So you see now in my slides those two types of abuse. And the Commission said that those two types of abuse followed a single strategy to foreclose the competitor. The biggest competitor of Intel was AMD from the most important sales channels in this chip market. Next slide, please. So still talking about the Commission decision. So the Commission presumed anti-competitive effects from the exclusivity rebates themselves. It said that there were potential effects on the basis of a qualitative and quantitative assessment. And the Commission also said that the potential effects were outlined via a quantitative as efficient competitor test. So that's a price cost test. And we will see later on why this is important. Next slide, please. So now we are talking about the first judgment of the General Court from 2014. And the General Court said that the legal test in these kind of rebate cases should be 3 types of rebates: pure quantity, volume-based, which are generally not abusive. Then you have conditional, quasi-exclusivity. If you have so if you don't have objective justification, they are inherently abusive, and there does not need to be individual examination. And then you have the third, other type of rebates, individualized, retroactive rebates. And there you need an individualized assessment. Next slide, please. So in the first judgment in 2014, as I said, the anti-competitive effects, according to the General Court, could be presumed from this type of conduct. So the General Court said that you don't need an analysis of individual circumstances. If there are potential effects required, then the Commission did require such potential anti-competitive effects, so it proved those kind of potential effects in its qualitative and quantitative assessment. And the General Court said that there was no need to conduct a price cost as efficient competitor test, so the General Court did not analyze Intel's arguments in this respect. Next slide, please. So rebates conditional on quasi-exclusivity, and then if there is potential for closure standards, there needs to be a qualitative analysis. Next slide, please. So what is interesting is that then this was appealed by Intel to the ECJ, and the ECJ quoted some case law. Primarily, you see in here the Hoffman-LaRoche case. This is paragraph 137 from the Intel judgment of the ECJ from 2017. And basically, this case law says that, you know, if you have a dominant undertaking and it's tying purchasers by an obligation to obtain all or most of their requirements exclusively from the dominant undertaking, so then there is an abuse of dominant position, and it does not matter whether that obligation is without further qualification or if it's in consideration of a rebate. So that's the case law. The ECJ cited this case law. The next slide, please. And in paragraph 138 of the ECJ judgment, you see the Court of Justice says that this case law needs to be clarified in a case such as this one, where the undertaking submits during the administrative procedure before the Commission on the basis of supporting evidence that its conduct was not capable of restricting competition, and in particular of producing the alleged foreclosure effects. Next slide, please. So that was paragraph 138. 139, the ECJ says that in that case, the Commission is not only required to analyze first the extent of the undertaking's dominant position, and secondly, the market of the market, so the share of the market covered by the practice, but also the conditions and arrangements for granting the rebates, their duration and their amount. The court says the Commission is also required to assess the possible existence of a strategy aiming to exclude competitors that are at least as efficient as the dominant undertaking from the market. So this is, the court is citing by analogy the post-Denmark judgment. Next slide, please. And in the paragraph 141 and following, the ECJ says that because the Commission carried out this as efficient competitor test, and because Intel was challenging that test and it raised arguments against the test, the General Court made an error of law because it did not even enter into that discussion and did not analyze at all this as efficient competitor test. So the ECJ has annulled the General Court judgment and sent it back for the General Court to assess anew this aspect. Next slide, please. So now we have the judgment of, so the second judgment of the General Court in this case from January 2022. You see that now the General Court has carried out a very detailed assessment of all the factual elements of this as efficient competitor test. For each OEM, the General Court has found different parameters not being sufficiently substantiated by the Commission. And so the General Court says that the test fails for all OEMs. then the General Court finds that any doubt in such a case must play in favor of the dominant company. The General Court also looks at the Commission's other effects analysis, the so-called qualitative analysis, and it finds that it does not fulfill the criteria of the ECJ judgment. And so the General Court has now partially annulled the Commission decision against Intel. And now the Commission has appealed this judgment. So as I said, the case is pending before the ECJ. Next slide, please. Thank you for your attention. I will try to pronounce Paldies par jūsu uzmanību. I think it was a little bit stressed together, but I wanted to cover both of these judgments because they are very important. Thank you.
Thank you very much. Pronunciation is wonderful, and your presentation, especially on the Google case, reminded me a good old-fashioned joke. If you want to hide dead body, the best place is the Google third page. Nobody's looking there. Thank you very much, Mr. Christoph, Court of Justice of the European Union. And the next presentation of ours is on vertical power, new vertical block exemption regulation and guidelines. My pleasure to give the floor to Esmeralda Balode-Buraka, University of Latvia, Rodl and partner. Madam Balode-Buraka, the floor is yours.
Yes, thank you, and it's my true pleasure to be here today, as well as to meet all the distinguished speakers, at least virtually. And I will indeed talk about the new competition regime for distribution in the European Union today. So first of all, if we may, the next slide, what is WEBER? Article 101, part 1 of the Treaty on the Functioning of the European Union, prohibits agreements which restrict competition. And at the same time, part 3 of the same article sets out the exception to this prohibition for agreements which contribute to improving the production or distribution of goods, or to promoting technical or economic progress while allowing consumers a fair share of the resulting benefits. So agreements between entities active at different levels of the supply chain, for example, manufacturer and distributor, are referred to as vertical agreements. So far, its basis. Competition law has established that vertical agreements may be able to benefit from the Article 101, Part 3 exemption. The vertical agreement block exemption regulation, or so-called WEBER, is a regulation which automatically grants an exemption for vertical agreements which comply with a set of criteria. Namely, two of them, it is for contractual parties, each have a market share below 30%, and it is important that the agreement does not contain any hardcore restrictions, as for example, it does not fix resale prices. The currently applicable WEBER or regulation was adopted in 2010, and just a few days ago, the new WEBER and its guidelines were published by the European Commission, and the new WEBER will enter into force in a few days, starting from 1st June this year. And the new regime is envisaged for another 12 years. It's also worth to mention that WEBER regime is applicable across the EU as it is a regulation. I have to note that there is a legal debate, both in conferences and social networks. What is the status of its accompanying guidelines? We all may recall that in principle, the same violation or potential violation of the competition law may be investigated and penalized either by the European Commission or by the national competition authority. So this can be the same facts, the same situation. And if a national competition authority disregards the guidelines, which according to the legal theory are non-binding. The result or the answer, particularly if the situation is or is not a violation of the competition law, might differ there. So in other words, the result may depend on the fact which authority investigates the case. And here I want to say that there must be a clearly and expressly defined reason in each and every case on the national side when it does not follow the guidelines. Then switching to the WIBOR itself. So the heart of the new WIBOR is Article 4. It sets out the so-called hardcore restrictions, which if included in agreement, will automatically remove the benefit of the safe harbor. And in the new WIBOR, in principle, the headline restrictions remain unchanged. And what is important for several distributors also here in Latvia is that resale price maintenance, namely restricting the distributor's ability to determine its sale price, unsurprisingly remains a hardcore restriction regardless of the distribution structure. And territorial and customer restrictions are also retained as hardcore restrictions. So what are the main changes with the new WIBOR? There are elements where the new WIBOR narrows the scope of the safe harbor as regards, first of all, dual distribution, that is where a supplier sells its goods or services through independent distributors, but also directly to end customers. And here I will illustrate it with an example. So although the WIBOR is aimed at vertical agreements, the safe harbor remains extended generally as before to dual distribution scenarios. And Article 2, paragraph 4 of the previous WIBOR grants a benefit of the safe harbor to non-reciprocal agreements between competitors, where, for instance, the supplier is a manufacturer and a distributor of goods, while the buyer is a distributor and not a competing manufacturer. And second, parity obligations, that is, obligations which require a seller to offer the same or better conditions to its counterparty as those offered on third-party sales channels, such as other platforms, for example, and or sellers' direct sales channels like its website. Here also the new WIBOR narrows the scope of safe harbor, and in particular, it will be no longer tolerated the situation where an online platform, e.g. intermediary, prohibits its client to offer the same product in another platform on different conditions. Apart from online, I have to note that this parity requirement remains allowed, of course, observing if the market share of contractors doesn't exceed 30%. And the next slide, please. So at the same time, the new WIBOR enlarges the scope of the safe harbor, and I will also name two examples. So first, certain restrictions of the buyer's ability to actively approach individual customers. And one of the examples here would be from an exclusive distribution system. And just to remind that exclusive distribution is where a supplier allocates territory or customer group exclusively to a distributor and can restrict other buyers from actively selling into the exclusive territory or to the exclusive customer group. This is often used by businesses that carry luxury brands such as Porsche cars, for example, iPhones, Gucci clothes, and so on. And the WIBOR will now allow the exclusive distribution supplier to demand a pass on of the active sales restriction to the buyer's direct customers. And the second situation where the new WIBOR enlarges the scope of the safe harbor is that certain practices relating to the online sales, namely the ability to charge the same distributor different wholesale prices for products to be sold online and offline, and the ability to impose different criteria for online and offline sales in selected distribution systems. And here I want to say that the most important here is that the pricing is that way is block exempted or allowed. And if we come back to the drafting process of the new WIBER, so the European Union's Commission's previous position was to protect online sales at all costs, but commercial landscape has changed in the last 12 years when the previous WIBER was in force, and even more so since the COVID-19 pandemic, of course. So we all have changed our shopping customs and more prefer online shopping. And given the shift, the Commission has fundamentally changed its focus, so requiring a distributor to pay a different price for products intended to be resold online than products to be resold offline, so-called dual pricing, was previously a hardcore restriction, but the guidelines make it clear that this will be no longer the case. Dual pricing will now benefit from the safe harbor as long as the restriction aims to incentivize or revert appropriate levels of investment respectively made online and offline. And here I will stop with my presentation and examples. I just want to say that all the safe harbors and vertical block exemptions are directly related with real businesses, with real business needs. So all the new exemptions are based on assumptions that this is from what market and also customers benefit from. So thank you very much.
Thank you very much to Madam Balode Buraka, University of Latvia role and partner, for sharing perspective on vertical power and new vertical block exemption regulation and guidelines. Thank you very much indeed. Considering our tight schedule and limited time, we have a mandate from organizers to jump over to the student section, because students are feeling themselves ready to go. And we are absolutely intrigued because our next session is called Rising Stars section, presentations by students of the University of Latvia. And what we are looking forward, the question on the assessment of the EU merger control in the digital era. There's going to be speech on the big tech. We're going to look on the indirect purchasers' rights and cartel cases in construction companies. Then it will be followed by the use of competition case evidence in civil and criminal proceedings, and we're going to finish with a reading on the application of national procedural autonomy. So all the topics are topical, like, excuse me, pardon me for tautological expression, but topics are topical. And we are absolutely happy to have our great young minds in the conference. So Rising Stars, we're going to start with the first speaker, Patricija Bodniece, University of Latvia, Assessment of the EU Merger Control in the Digital Era, Acquisitions by the Big Tech. Madam Bodniece, the floor is yours.
Good day, dear listeners and panelists. My name is Patricija Bodniece, and it is my great honor to open our last section of today's conference. Most notably, I would like to say a big thank you to all the organizers of the event. This is a very great opportunity to talk about the very important issues around the competition law field. As to my presentation, it is focused around digital tech because in the recent years, there has been a rapid expansion in the digital economy, thus placing our lives in the hands of companies that basically dominate the digital market, which is Google, Amazon, Meta, or Facebook as we knew it till this day, Microsoft, and Apple. While the digital economy has been expanding in an extensive acceleration, there has been a growing debate around how the digital market should be regulated throughout the competition law lens. and how to apply this law in such complex markets. Thus, the topic of my today's discussion is the assessment of merger control in the digital era, acquisitions carried out by the big tech. We can move along to the next slide. Throughout the research, two main questions have been addressed, thus analyzing the following: regulatory changes and killer acquisition topic. So if we're speaking about the regulatory changes, it was important to understand what are the changes that have to be implemented in the current regulation of the European Union to address the mergers and acquisitions in the digital sector, and if such changes are even necessary. And the second topic is a very interesting phenomenon coming from the pharmaceutical industry into the tech industry, killer acquisitions, to understand if these acquisitions carried out by the big tech are the real threat to competition and consumer welfare, and if even such acquisitions are happening. We can move along to the next slide. So the EU merger control aims to distinguish between non-harmful and harmful transactions that either block or modify a concentration between the parties involved. To achieve this monitoring effect, the primary vehicle used is the Council Regulation number 139/2004. This regulation requires parties entering a concentration to notify those concentrations having a community dimension and reaching certain turnover thresholds to the Commission for their prior approval. When talking about the turnover thresholds, it is noted that they include the so-called 2/3 rule. So this means that the transactions that involve two or more parties in which the thresholds set out in the regulation do not reach the limits will in fact fall outside the Commission's jurisdiction. Thus, taking this into account, it is very understandable that transactions that involve products or services that are being provided for free, as they usually are in the digital markets, will fall outside the Commission's jurisdiction unless the parties generate the turnovers in some other ways. One other interesting aspect of evaluating digital mergers is defining the relevant market. To put the relevant market definition into perspective, when examining the digital mergers, we can look at the relevant market definition in the WhatsApp Facebook case. So in this case, when examining the relevant market, the Commission concluded that the market includes the traditional electronic communication services, while they later concluded the geographic market cannot be determined, guessing that it shall be worldwide because we use these services all over the world. However, when examining the product market, the Commission assessed that it would leave open the product market because it didn't necessarily mean and raise any doubts about the compatibility with the internal market. However, the Commission was struggling to define the product market because of this being a digital merger. So, as we all know by now, a clear path of defining a relevant market is already a very complex and hard exercise, and involves very much of economic analysis. However, it has become even more difficult since in the digital sector, the relevant market really tends to vanish. Next slide, please. So talking about the novel harms of the big tech, the primary business for the digital economy is the platform in which the company operates. And the data which it generates is a vital characteristic of the digital market, as it usually acts as a raw material and a currency in such markets. The digital economy gives rise to various strategies to achieve competitive advantage. So significant network effects leads to winner-takes-most competition, which is very similar to one winner-takes-all approach, but not necessarily the same. In the digital economy, what constitutes an established or a potential competitor also becomes blurred. So if we're looking at the challenges of regulating the mergers in the digital economy, well, they pose many, because the competition law, the basic tests embedded in the competition law and the concepts are difficult to be applied in the digital economy. Much of the existing competition law focuses on the prices, but it is very unsatisfactory in situations where customers are provided with services seemingly for free and where the competition is on innovation rather than on price. Furthermore, the cost arrangement of digital platform companies with near to zero marginal costs of distribution are very different from those of traditional linear companies as we know it today. And taking this into consideration, some member states and even the European Union have detected the novel harms of the big tech and what they can impose, looking at the mergers that are not being investigated only because they do not exceed the set thresholds in the national jurisdictional level. Thus, member states are making changes to applicable legislation to avoid such acts as killer acquisitions or anti-competitive deals from happening. If we're talking about killer acquisitions, which is a very, very interesting phenomenon, it can be explained in simple ways by considering when a dominant company acquires a growing startup. While the startup is outside the monopoly market, it is usually a horizontal threat to the monopoly because it operates within the same user space. In an empirical study concluded by economists some years ago, a comprehensive data set was gathered by pharmaceutical drug projects. And in this study, the economists identified acquisitions where acquirer companies purchased companies which were in the process of creating an overlapping drug and discovered that post-acquisition terminations of such companies were concentrated among overlapping projects. The digital industry shares some standard features with pharmaceutical industry, such as long product life cycle or intellectual property rights. So meanwhile, in the digital sector, there has been a review carried out that in 2019, that showed that in the last 10 years till then, the big tech, those companies, those 5 companies, together concluded around 400 acquisitions globally. And they showed that these companies spent over $31 billion only acquiring small startup companies, and very few of these companies were actually examined by the Commission or the FTC. And another study showed that 105 mergers that were concluded, the companies discontinued the products or these companies within a year of acquisition. Certainly, discontinuation of services and products of an acquired company does not immediately mean that there was a killer acquisition. However, discontinuation is very consistent with the killer acquisition strategy by the acquirer company. Next slide, please. So, in conclusion, there are many scholars that state that current tests have to be changed in order to assure a higher degree of merger control in the European Union. However, I would tend to disagree because changing the current tests will not solve the problem of anti-competitive mergers from happening. I would propose that the burden of proof to be revised. Such revisal would only apply to big tech giants or as we all know by now, the gatekeepers. It would happen so that the Commission would ask the acquirer company to provide sufficient information on how the acquisition is pro-competitive, not the other way around. So to put this into perspective, if the revised burden of proof would apply in the Facebook WhatsApp case, Facebook would have had provided Commission with information on how, without the takeover of WhatsApp, either the customers would lose or WhatsApp would not be able to survive as a standalone company and because of some financial problems and maybe because of particular synergies or efficiencies that would rise because of this acquisition and would hold positive effects. And about killer acquisitions, it seems that killer acquisitions for now have lost their meaning in the digital sector, which is quite easy, a company being acquired and then discontinued, thus killing the previous company. The term has been overly popularized because some scholars are proposing that even such mergers as Facebook and Instagram, as well as Facebook and WhatsApp, are killer acquisitions. However, I would tend to disagree with this proposal because these companies still exist and are operating. They are not standalone companies, but they still operate in their user space. Nevertheless, we can never know if the next big thing was killed, and this is a very prominent question around competition law. So how do we deal with uncertainty? And this is where I leave you because, yes, this is a question to be researched. How do we deal with uncertainty? Thank you very much. You can move to the next slide. Yes, and if you have any questions, feel free to ask.
Thank you very much to Madam Bodnīca, University of Latvia. In fact, I have a question. We, in the previous day, already this term killer acquisition was coming out on the table, and you're saying that this is overly popularized and losing its meaning in the new frames of shifting markets. The question is, what would be your recommendation to replace the killer acquisition with what kind of term, keeping in mind that there are still the phenomenon that is a risk to finishing the business in the particular company? What would be the proper replacement or the direction where discussion should be led for the replacement of killer acquisition?
I wouldn't believe that we should replace a term of killer acquisitions. I just think that there isn't enough research carried out in other sectors. For example, the linear companies between some other mergers happening, because killer acquisitions have been emerged from pharmaceutical industry and they have been circulated around in the digital industry now as well, but we never really hear about killer acquisitions happening in linear companies in some other markets which are not maybe that relevant. So I do believe that the killer acquisition theory has been around in the digital markets only because we do not know how to regulate these markets. We don't have any particular laws and regulations in place just for the digital market, and it is such a fast-moving environment, and it is hard for the law to actually move along with the possibilities of what the big tech can impose. So I do believe that we shouldn't pose away from killer acquisition theory as such. We should just see how the digital sector evolves and carry out more researches and carry out these researches in different markets, not only in pharmaceutical industry or the digital sector.
Thank you. Thank you very much for your answer, Madam Bodnīca, University of Latvia. And we are moving forward to next presentation, indirect purchasers' rights to claim damages in the cartel cases of construction companies. Artūrs Punculis, University of Latvia. Mr. Punculis, the floor is yours.
Good evening. My name is Artūrs Punculis. It's an honor to be here and to be invited. The name of my topic for discussion is indirect purchasers' right to claim damages in cartel cases of construction companies. As for today's agenda, I will shortly describe the real example of possible claim for damages and gradually will explain why indirect purchasers in cartel cases of construction companies are or could be entitled to claim damages. Next slide, please. In order to put theory in practice as the basis of my discussion, I have taken a real example of the acquisition of the shopping center Alpha in Riga, Latvia, and shortly we'll try to explain why Acropolis Group could be entitled to damages in the case if the Administrative Court of the Republic of Latvia finds that construction company Merks has infringed competition law. Even though the Competition Council has adopted the decision on finding an infringement and imposing a fine on construction company Merks, which reconstructed Alpha after the Competition Council received the merger notification of Acropolis Group and Delta Property. But if the conditions described next apply, Acropolis Group shall be entitled to claim damages as an indirect purchaser. Next slide, please. Merks carried out the reconstruction and extension of the shopping center Alpha in the year 2019, when the owner of the shopping center was the Delta Property. In 2021, Competition Council of the Republic of Latvia adopted the decision on finding an infringement and imposing a fine on Merks and other 9 companies which participated in cartel, which definition is as follows: a collection of independent businesses or organizations that collude in order to manipulate the price of a product or service. And in the same year, 2021, the Acropolis Group acquired the shopping center. In this case, the Acropolis Group is considered to be an indirect purchaser because the company has acquired not directly from an infringer, but from a direct purchaser, an immovable property, which is an object of an infringement of competition law, or in other words, because Acropolis Group acquired the shopping center from Delta Property, which is an object of reconstruction works in the amount of 55 million euros, and the right to these reconstruction works are considered to be obtained because of the fact that it was arranged in the meetings of cartel. For the reasons described previously, Acropolis Group is considered to be an indirect purchaser. Could I ask the next slide, please? As a rule, a person who has suffered damages as a result of an infringement of competition law is entitled to claim and receive damages from the infringer, including lost profits and interests from the date on which the damages were incurred until the date on which the damages are paid. In this scenario, the burden of proof of the existence and extent of such passing on to the indirect purchaser is on the party who claims the damages from the infringer. There have also been developed methods to prove and determine the amount of damages. Some of the methods, for example, are comparison over time, comparison with unaffected market, cost-based and financial methods, and others. In the case of competition law infringement, it could and is very difficult for the claimant to quantify the damages, as in fact, it would have to compare the economic situation of the victim as a result of the competition infringement with the hypothetical economic situation if the infringement had not occurred. Sometimes it is practically impossible to quantify or difficult to determine precisely the amount of damages. In these cases, the court is entitled to take the next step and award compensation on the basis of a sense of justice and general principles of the law. However, if the infringement takes the form of a cartel agreement, the infringement is presumed to have caused damage and results in a price increase of 10%, unless, of course, otherwise proved. Concerning to the determination of the amount of the price increase, the court primarily assesses it based on the available evidence and available empirical studies on the effects of cartels, and only if no indications on the amount of the overcharge are available, the court applies the 10% price increase presumption. And as of 2017, when the Latvian legislature incorporated the so-called damages directive into the competition law of the Republic of Latvia, it has been provided that the indirect purchaser is also entitled to claim damages if it proves that three cumulative conditions are met. If I could ask for the next slide, please. Respectively, the indirect purchaser has proven the passing on of the overcharges onto him or her if the indirect purchaser proves that the defendant has infringed competition law. The infringement of competition law has resulted in an overcharge to the direct purchaser of the defendant, and the indirect purchaser has purchased goods subject to the infringement of competition law or goods which have derived therefrom or which contains such goods. So in this case at hand with the Acropolis Group and shopping center Alpha, although Merckx has appealed the Competition Council's decision to the administrative court and the court has not yet declared the judgment in the case, for the purpose of this discussion, I will say that Merckx has committed an infringement of competition law, and therefore it can be concluded that the first condition is met. Secondly, the indirect purchaser is required to substantiate and prove its damages claims by arguing that the direct purchaser of the infringer has passed on the relevant overcharge to them and that the indirect purchaser has thereby been harmed. The reconstruction of buildings generally prolongs their useful life, increases their utility value, and last but not least leads to an increase in their value. To determine the increase in value after reconstruction, the open market value of the sample building relative to its technical conditions before reconstruction is established using the comparative valuation method. This method consists in finding an array of buildings that most closely match the predefined parameters with the valued building. Usually, when using this method, the bid prices for individual comparable constructions are used. The total price of the reconstruction work is then calculated in the open market value of the sample building after reconstruction established. Finally, the change in the value of the sample building after reconstruction is determined. So in order to prove whether the passing on has happened, it requires an extensive calculations and, of course, knowledge on internal documents or agreements. However, any owner of real estate, let alone a commercial real estate owner, has a legitimate desire to make a profit on the sale of the real estate, including a return on the investments made. And accordingly, it could be reasonably concluded that the cost of construction works has affected the value of the shopping center Alpha, and moreover, the price increase because of the cartel agreement, which has been passed on by the direct purchaser Delta Property to the indirect purchaser Acropolis Group. However, as I'm not informed about any internal documents or actually price of the building, as it was not made public, it is possible also that the Delta Property has passed on the overcharges to the, for example, the tenants of the shopping center, or it's possible that the passing on has not happened at all. And the third condition requires that the product bought by the indirect purchaser must be subject to the competition law infringement, or must be derived from or consist of the project subject to the competition law infringement. In the construction cartel case, the Competition Council has indicated that the relevant product market is the construction of civil engineering works, and the relevant geographic market is the territory of Latvia. There's also no dispute that Merx carried out the reconstruction works in Alpha, and without doubt, it can be considered that reconstruction works are part of the mobile property, in this case, the shopping center Alpha. Therefore, even though shortly described because of the limited time I have here, it can be concluded that the Acropolis Group could be entitled to damages as indirect purchaser if the three cumulative criteria are met. And it's because of the principle which underlies the entire damages directive, it must be understood as requiring that the person entitled to claim compensation for the harm suffered must be placed in the position in which the person would have been had the infringement not been committed. Next slide, please. And to summarize shortly, a person who has suffered damages as a result of an infringement of competition law is entitled to claim and receive damages. Sometimes it's practically impossible to quantify or difficult to determine precisely the amount of damages. And there also has been developed methods to prove and determine the amount of damages. The infringement takes if the infringement takes the form of a cartel agreement, the infringement is presumed to have caused damage and results in a price increase of 10%. As of 2017, it has been provided that the indirect purchaser is also entitled to claim damages if he or she proves that the conditions are met. And lastly, it can be concluded that the Acropolis Group as an indirect purchaser could be entitled to damages. Thank you.
To Mr. Puntulis, University of Latvia. The quick question, maybe outside the field, in fact, you mentioned that during the process you are analyzing, there are some lack of data. We know that we don't know some things. What would be your recommendation, considering national legislation or something, considering construction field as it is? Should there be transparency increased in some fields or momentums, and how it is interbalanced with commercial secrets and business interests?
I do believe that the state as such cannot make construction companies or entities who sell or buy any immovable property to disclose information that they do not wish to disclose. And it would not be just possible, it would also be not fair to them, because it is at the end commercial secret. And this situation at hand, I do believe that the Acropolis Group could and can ask for more documentation to prove their case. But as such, it is, let's say, gray field, and it would be hard to prove and to say that the passing on has happened. But in theory, as such, there is a possibility to do so.
Okay, thank you. Thank you very much to Mr. Puntulis, University of Latvia. And we are moving forward with the next speaker, the use of competition case evidence in civil and criminal proceedings. Madam Linda Lielbriede, University of Latvia. Madam Lielbriede, the floor is yours.
Thank you, Mr. Baubulis. Good afternoon, dear participants. My name is Laila, and I am honored to use this opportunity today and provide a brief insight on the problem, how to ensure the effective implementation of the Competition Council's investigative measures by obtaining and procedurally consolidating evidence without violating the rights of defense of market participants or litigants. Next slide, please. The main purpose of competition law could not be achieved without the Competition Council conducting a full-fledged investigation of the possible infringement of the competition law. Nonetheless, it is well known that cases initiated by the Competition Council, their factual circumstances, and even evidence obtained during the investigation process of this possible violation often serve as a basis for initiating civil cases or even criminal proceedings. Next slide, please. And it has been emphasized in the law of in the case law of the General Court of the European Union that the investigative measures taken by the National Competition Authority, especially during the preliminary investigation phase, such as inspections or requests for information, by their nature already constitute an allegation of an infringement of competition law. Therefore, in obtaining information and consequently evidence of an alleged infringement, it is essential and important to prevent the rights of defense being inevitably diminished, which is very easy already in this phase of the process. Therefore, in competition cases, it means that effective rights to defense must be seen as essential guarantee of the right to a fair trial, understanding it in the broadest sense of the word. At the same time, it has also been recognized that the entity has an obligation to actively cooperate with the competition authority by answering questions or by issuing documents containing information which is necessary for proper investigation of possible competition law violation. However, a company's duty to cooperate does not allow it to evade this request on the grounds that by submitting these documents or providing some explanations, the entity would be forced to testify against itself. And therefore, put it in other words, it would mean that the entity has the right not to incriminate oneself or to admit this infringement, but it does not have the right not to provide explanations or even provide some sort of documents or information that is necessary for the competition authority. Next slide, please. Therefore, I must turn to one of the most important rights of the defense in competition law, which is based on proving the infringement and consequently the standard of proof and also the burden of proof. Considering the general requirements that regard the assessment of evidence in the competition cases, it should be noted that admissibility of evidence shall consider the origins of the particular documents, also the circumstances in which they were obtained or the circumstances in which the explanations of the market participants were given. And I should say that relatively rare are the cases when only one document may be decisive in a competition case. For example, if a person with direct knowledge of the facts report this violation, it also should be corroborated with the other evidence already obtained in this particular investigation process. And also, I should say in this regard that the basic principle of proof in competition law is that the infringement must be proved by the party alleging it. Therefore, in administrative proceeding, the initial case, this burden is shifted on the competition authority. In civil proceedings, it will be the party seeking the restitution or seeking the compensation of damages. But usually this party is also accompanied in some level with the assistance of the National Competition Authority. And in criminal proceedings, it is the Public Prosecutor's Office. Next slide, please. I must say that evidence plays crucial role in competition cases, but most important, it is the implementation of the proper implementation, I would say, of the so-called leniency programs, and in providing that the legal consequences of leniency programs are properly ensured. Therefore, if the market participant is seeking an exemption or reduction of the penalty, also being a participant of a cartel, at the same time, this entity already provides information which is self-incriminating. We could definitely say that this information includes statement that this entity admits of having participated in some sort of competition law infringement. Therefore, there may be a situation in which this market participant not only provides this information, but also in fact accuses itself for being a participant of this infringement. And there is a certain risk that this self-incriminating material may be disclosed outside the investigation procedure for which it was provided. And therefore, this risk, which is, I would say, inevitable in Latvia's situation, may actually weaken the incentive for potential leniency applicants to cooperate with the competition authorities. And therefore, it must be noted that regardless of the form in which the evidence is presented under the leniency program, this information should be used only if it's necessary for the exercise of the rights to defense, and I would say only in the administrative proceedings. Next slide, please. And bearing in mind what I just said, I must draw your attention to the fact that in civil cases, the legislator in Latvia has already chosen to determine that the possibility of such of admissibility of such evidence in civil cases is diminished, emphasizing that a person who uses access to a case file of a competition authority may not use these testimonies which were provided within the scope of leniency program and which include voluntarily provided information by the particular market participant. Similarly, the civil procedure law prohibits the use of evidence obtained by accessing the case materials of competition authority, which contain the market participant's recognition of this violation, whether he took part, or which also contains this participant's refusal to contest its participation in the particular infringement. Therefore, it may be concluded that currently there are objective legal restrictions in civil matters on the use of de facto self-incriminating information, and this therefore protects market participants from the outcome of proceedings in which the adversarial principle is virtually disregarded. Next slide, please. But I must note that this situation is not so favorable to a market participant in those cases when the information submitted to the Competition Council or obtained by the Competition Council become a part of materials of a criminal case. And this view can be explained by the fact that legal doctrine on criminal offenses provided for in Articles 211 and 212 of the criminal law does not express the opinion that participation in a leniency program or active admission of the competition law violation would exclude liability for possible criminal offenses or limit the use of such evidence. Therefore, during the criminal proceedings, when investigating a particular case, a situation cannot be excluded in which the person conducting the proceedings obtains such evidence or requests it from the Competition Council, and therefore can add to criminal proceedings some materials that were actually initially submitted by the market participant itself. And in this aspect, noteworthy is the current position of the Competition Council, namely that the conduct of two different but temporally simultaneous proceedings, administrative proceeding and the criminal proceeding, does not lead to their actual or legal merging into one. There, I couldn't really object. However, this also means that the conduct of the leniency program is not a factor that would exclude possible criminal liability, even though the information provided to a competition authority to achieve the legal consequences provided by the leniency program often are self-incriminating, also including as a means of proving entities or even natural persons it's guilt in being responsible for even criminally punishable actions. And therefore, I must say that the assessment of this particular issue is closely linked to the practical effectiveness of national leniency programs. Nonetheless, I would say that there are several solutions that can be offered to this problem. Next slide, please. Firstly, when providing defense in such criminal proceedings, the defense attorney should immediately draw the attention of the investigator that criminal procedure law precludes the use of such evidence which were obtained by violating the basic principles of criminal proceedings. And therefore, I must note that it is clear that leniency program and the provision of information in which a market participant actually admits of having committed this infringement are contrary to the right not to incriminate oneself or to provide incriminating information. And in this respect, I would agree with the finding in the case law of the Regional Administrative Court that explanations provided by the applicant to the Competition Council cannot be used later in criminal proceedings as evidence against the entity or as evidence against the person itself. Therefore, it must be noted that when providing the information to Competition Council, the market participant does not have any procedural guarantees to ensure that this information would be excluded from the scope of evidence that later would be hypothetically used in criminal proceedings. And in addition to this, I also must note that while the doctrine of poisonous tree is not recognized in Latvia, that means that market participants' right to defense or right to fair trial in this process is, I would say, seriously and significantly violated. And yes, next slide, please. And secondly, when looking at this particular problem, legislators' attention should be drawn to consideration that section 130, paragraph 2 of the criminal procedure law should be amended or at least revised in a way that this particular provision would stipulate that information provided under the leniency program is not to be used as evidence in criminal proceedings, preventing it from being requested from the Competition Council by the investigator in the particular criminal proceedings. And in this regard, I should also note that elsewhere, for example, in the United States, this particular issue is addressed through the corporate letters of conduct, in which it is addressed whether or and how a market participant's information, explanations, any source of confessions may be used later on in civil proceedings and also even in criminal proceedings. Next slide, please. This brief overview should put an emphasis on the fact that in criminal competition law related cases, the removal of procedurally inadequate evidence should be ensured as soon as possible to prevent the investigator from developing a completely subjective and some may say even cognitively dissonant attitude towards the circumstances of a particular case. And evaluating the issues considered, I may conclude that the importance of evidence obtained in a competition case in civil proceedings is essential. Therefore, it is permissible insofar as it does not infringe the basic rights and legal interests of market participants, both legal persons and natural persons. Whereas in criminal proceedings, such evidence is of limited and secondary importance, and in particular, it is regarded to its admissibility and the fact that evidence requested from the Competition Council actually includes self-incriminating information, which is contrary to the basic principles of criminal procedural law. Therefore, such information and evidence should be excluded from use in criminal procedure while the investigator has not found a way how to not interfere with basic principles and the rights of defense of the market participant. And then next slide, please. Thank you for your attention and for listening to this presentation.
Thank you. Thank you very much to Madam Lielbriede, University of Latvia. In the final conclusions of yours, of very insightful presentation, you mentioned that there are different practices in different member states. How Latvia, with its legal doctrine, looks on the map of European Union? Are we island of legal thinking, or there are other countries with a similar situation as we have?
I would just say that answering to your question, it should be viewed in a way how we look at competition law infringements. And it is a well-known fact that the Court of Justice of the European Union has already stated that competition cases actually have this criminal nature. And therefore, I think that Latvia's legislator also should evaluate how and why we impose criminal sanctions or in cases which already were viewed, or even a penalty, quite huge penalty was imposed on the market participant. Therefore, I think that in the map of Europe or even global antitrust legislation, Latvia still has enough space for growth. Thank you.
Thank you very much for your answer, Madam Lielbriede, University of Latvia. And we are going to the, as they say, last but not the least, the speech today, the application of national procedural autonomy. Madam Maruta Kalpinova, University of Latvia. Madam Kalpinova, the floor is yours, and have a very nice presentation.
Thank you very much. Good afternoon, Good afternoon, everyone. My name is Marta Kalpinova, and first of all, thank you very much for having me as a participant here in this conference. I am only a student in the process of earning my master's degree in law in the University of Latvia, and just last week I defended my master's thesis in this very subject in competition law. And interestingly enough, one of the very first inspirations to write my master's thesis in competition law over any other subject in law was this conference that was organized last year. And it is therefore truly an honor to be here today. And can we go to the next slide, please? So for the agenda, today I will be presenting some of my conclusions to further continue the debate regarding the application of national procedural autonomy. I will briefly sketch the principles on successful phrasing, the general limits of application, and also invite you to further consider the convergence of EU and national member states' procedural laws. Can we go to the next slide, please? Thank you. Admittedly, I believe and I have concluded that the term national procedural autonomy is unsuccessful and can be quite confusing. To briefly explain, before we go to the term, to briefly explain the principle itself, each member state of the European Union independently introduces its own laws to deal with procedural matters, according to the principle of national procedural autonomy. However, this principle does have restrictions, namely the principle of effectiveness and the principle of equivalence. We will talk about these principles later on. And additionally, procedural autonomy is not applicable where European Union rules already exist. So first things first, the imposition of any conditions itself, namely principles of effectiveness and equivalence, demonstrate that member states do not have full autonomy over the application of their rules. And secondly, the very principle of procedural autonomy states that the ECG has recognized that national procedural autonomy may be exercised in the absence of pre-existing European Union rules. So, therefore, I do share the view of some law practitioners that the phrasing of national procedural autonomy is quite unfortunate, and it may give a misleading impression that there would be a complete autonomy for the member states of the European Union to adopt and apply their own procedural rules. In my view, the misleading phrasing could be one of the root issues why the practice of the National Competition Council shows some apparent inconsistencies in the application of national procedural autonomy. Namely, to further explain this, I would say that in some cases, the Competition Council reflects on and emphasizes the national procedural autonomy. However, in others, insists on applying EU procedural practices and does not hold a very strong and solid viewpoint on the application of national procedural autonomy and often don't really mention it in their decisions. Can we have the next slide, please? So in the case of VM Remons, ECG found that the Latvian national law on competition was drafted in the light of the need to align national competition law with the European Union. And below you can see the general application of national procedural autonomy and how it is currently defined in the EU. I would like to draw your attention to the definitions of the limiting principles. And later, it is worth mentioning that in 1998, in the case of Leves, the ECG stated that the principle of equivalence requires that the rule in question is to be applied regardless of whether alleged infringement is an infringement of European Union law or of national law, provided that the objective and the reason are similar. In this context, I would propose to expand and support cooperation between the national competition authorities and the respective authorities of the EU. One great example of this would be when in doubt as to whether the national procedural rule in question complies with the limits of national procedural autonomy, it is necessary to actively exercise their rights under Article 267 of the Treaty of the Functioning of the European Union and apply to ECG by way of preliminary ruling. Can we get to the next slide, please? Lastly, speaking on the further achievements of convergence of EU and national procedural laws, I would like to propose an example of my points. So Section 26, Paragraph 7 of our competition law states the following can be seen. Well, in the presentation, I have cited the article. I would like to point out the parts I have shown in bold. So in short, under the existing law, the participants are given 20 days to give additional information and their viewpoint of the case. The Competition Council need not take into account information which has been received after the end of the set period. And also, there is no way under the existing law to prolong the set term of 20 days. The Council is also under no obligation to record their sessions, which will be important later on in the next slides. And can we go to that, please? So here you can see my proposed changes. The idea of these proposed changes are to further convergence the national competition procedural laws with the laws of the EU to, in my humble opinion, better ensure the rights of the participants in the process. And so 2 months long term I noted here, and the possibility to prolong the set term, as well as the recordings of the Council sessions can be found on under the European Commission's practice when conducting their proceedings. And under my proposed regulation, as you can see, I propose to lengthen the term to a month with a possibility to prolong this period depending on the complexity of the case and maybe other mentioned ways, and also to suggest that the oral hearing should be recorded with the possibility of the parties of the hearings to receive the recording, and this is very important in my opinion. I also suggest to strike out the parts of the existing regulation that says the Council need not take into account information which has been received after the end of such time period, because those are already the rights of an institution in case a deadline is missed by a party. That's in general under the law. And if any procedural rules are under examination in a case, we need to remember that according to the ECJ case law, each and every member state needs to ensure that the rights conferred on individuals by EU law are not undermined. In particular, the right to an effective remedy and to a fair trial as set out under Article 47 of the Charter of the Fundamental Rights of the European Union. And can we go to the next slide, please? In conclusion, and in my opinion, these changes and further convergence is the very logical next step in our fast-moving world and economics, where we need clear, transparent procedural rules that strengthen and develop free, fair, and equal competition. Thank you very much for your attention. This will be the end of my presentation, and may you all have a lovely weekend.
Thank you very much, Maruta Kalpinova, University of Latvia. Before we go to the weekend, a question. Your presentation was very much focused on the spirit of recommendation, what should be changed and how should be changed. Maybe you can evaluate a bit on the first steps, what should lead to changes in this field, and who would be responsible for that, who we should call after your presentation to start the change.
Well, I wouldn't comment on calling someone after this presentation, but I would propose changes in the legal system or for the Competition Council to interpret our laws according to the very essence of the European Union rules. However, as my example that I mentioned is that the laws are quite different and there are very distinct rules that, well, are very different than in the European Union's laws. So that would be my suggestion, to look into changing the laws we have step by step, of course, and under further debate and discussion. Thank you.
Thank you. Thank you very much to Madam Kalpinova, University of Latvia. Also wishing a good weekend, at the same time saying Thank you very much indeed for all participants in the conference and, of course, to you, dear audience. Today we grasped the very complex issue of competition law in this conference, which is already a traditional set of conference. Considering competition, we were seeing each other in last year, this year, and probably the next year around the same season. Conference will be continued, which is a very good news. Taking into consideration the many questions were open today in the discussions, complex issues, complex answers. But one thing we know definitely is that discussion needs to be continued on the issue of competition law. We have big players, the gatekeepers, the market shifters. We have national states, national institutions, and of course European Community, European Commission. And all of those players are seeking for balance for the competition, free market economies and states to blossom and to develop. Thank you very much for being with us today. The record will be available after this conference, so if you are interested in, you can rewind and rewatch, or like in the Netflix, do the binge watching of the best episodes. Thank you very much and have a good weekend.